Peak Beach, if we could all please rise for the Pledge of Allegiance. I pledge allegiance to
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Member Schmidt.
Here.
Member Core.
Here.
Vice Chair Garshaw.
Here.
Member Small.
Here.
Chair Chase.
Here.
We have a quorum.
We'll start our meeting with the approval of the agenda. Are there any changes to the agenda today?
No, Madam Chair, no changes.
Motion to approve the January 28th agenda.
So moved.
Roll second. Roll call, please.
Member Core.
Yes.
Vice Chair Garshaw.
Yes.
Member Small.
Yes.
Member Schmidt.
Yes.
Chair Chase.
Yes.
Motion carries.
At this time, we have the opportunity to take audience comments if there's a case or an issue that you'd like to address the board with that's not on today's agenda. If you'd like to speak on an item on today's agenda, there are yellow cards in the back of the room that you can fill out and provide to the clerk. But if anybody would like to share something with the board today outside of the scope of the agenda, we're happy to hear from you now. Hearing none, we'll move on to approval of the minutes from last month's meeting. Did everybody have a chance to review? Any questions or comments?
Yep.
No. Do we have a motion?
I move that we approve the minutes. Second.
Roll call, please.
Vice Chair Garshaw.
Yes.
Member Small.
Yes.
Member Schmidt.
Yes.
Member Core.
Yes.
Chair Chase.
Yes.
Motion carries.
We have 3 cases for today's meeting. Before we move into discussing the first case, our attorney would like to remind everybody about the nature of the quasi-judicial hearing that we're here today for.
Thank you, Madam Chair. Yes, today on your agenda you have 3 items. They are all variances. 2 are unnecessary and due hardship cases. The remaining case is a practical difficulty variance case. So under Florida law, variances have been considered quasi-judicial in nature. And what this requires is that your hearing today comply with some procedural requirements that have been established in Florida law and in your land development code. So these quasi-judicial proceedings, they will be less formal than a proceeding before circuit court, but they will be more formal than the remainder of your meeting, and they must follow basic standards of due process that requires everyone having certain notices, the application of the correct standards and criteria, and that your decisions be made on competent and substantial evidence that's presented to you today, either in written documents in your agenda packet or through oral testimony. Your responsibility today as members of the Board of Adjustment is to evaluate the testimony and the documents, and for each item, each of the 3 variances, and then draw a conclusion regarding whether the criteria in your land development code regarding variances has been satisfied. So speculation, I think, or an opinion that is not based on competent facts cannot legally be considered by you in evaluating whether or not a criteria has been satisfied. Any testimony by professionals who are qualified as experts in a particular area has been considered competent evidence by Florida courts, as well as testimony by neighbors and residents who have fact-based information such as minutes, surveys, engineering reports, or if their testimony is based on their personal knowledge that they have. Your decision is final. If a decision of approval is not obtained, there is an opportunity to present an alternative motion for approval with perhaps different conditions. If you choose to deny an application or a request for a variance, the reason for the variance denial must be stated in your motion. And generally, it would be because of the lack of evidence to support one of the criteria that is required by your code. In the event that there is a denial, your code provides that the same application for a variance cannot be granted or cannot be submitted for 6 months. So those of you who are in the audience, having heard my comments, please keep them in mind. When you come forward to provide any oral testimony, state your name clearly for the record and whether or not you've been sworn in, and your qualifications or your interest in the matter. So for purposes of efficiency, before we begin your action items today, I'd like to go ahead and address a few items for the record. First of all, I need to ask whether or not the 3 variances have been properly noticed. And I would ask staff and the town or city clerk. I think I'm hearing yes. Okay. Also, I want to ask if any members of the Board of Adjustment have a conflict of interest under Florida law that would prohibit you from voting on any of the 3 variances today.
No.
Okay, so we have a quorum present. At this time, it would be efficient to go ahead and ask anyone who's in the audience to go ahead and stand and allow the city clerk to administer the oath so that your testimony can be entered into the record for the various variance items.
Anyone who will be speaking to the board or making a presentation needs to be sworn in. Please raise your right hand. Do you swear or affirm that the information or factual representation that you are about to give or present to the board is truthful? Yes. Thank you.
As I mentioned in my comments, individuals who have been sworn in as experts based on their experience and other qualifications has been considered to be competent and substantial evidence. I believe before the Board of Adjustment, the city staff has already been determined to be experts in the area of land use in the city of St. Pete Beach. At this time, if there's anyone in the audience that would like their testimony to be considered as that of an expert, it would be very helpful to go ahead and have you rise and let the Board of Adjustment consider your qualifications and your ability to testify as an expert. I do not see anyone. Okay, so moving on. Madam Chair, if you would like to go ahead and read the first item, the first variance, and then followed with ex parte disclosures.
Our first case for this afternoon is case number 25142, 702 Paso Grill Way. Can we review any ex parte for the board?
No. Just a site visit.
Yep, same.
Site visit, and I watched yesterday's historical board presentation.
did that as well.
Site visit, and I spoke to somebody whose property abuts the 702.
I had a site visit and I encountered Brandon Tecklenburg, the owner. He showed me the alleyway in the back.
All this stuff.
I also received an email from Protect St. Beach, which was also addressing this topic.
We all got that.
Okay.
Thank you.
Madam Chair, there have been a number of emails and letters that have been provided regarding this item. I'm going to defer to Kristen to identify those for the record, and I believe that everyone has received a copy of those and that they have been added to the agenda.
Madam Chair, if I may, we have received, since agenda posting, 53 total emails or letters. I have not been able to calculate in support or against at this time. If you would give me just a few moments with a staff presentation, I can calculate that out. I will note that not all of them were specifically to the variance request. Some may have broadened their horizons on whether the development of the property was in question. So I've kind of tried to weed those out a little bit for you, but I can have a better understanding, but I have provided every piece of information staff has received.
Thank you very much, Kristen.
welcome.
And I think that's important just to ground everybody on the nature of this variance, which is to allow the retention and expansion of a driveway access from Paso Grill Way following the redevelopment of 702 Paso Grill Way. So that's the matter that we're discussing today.
Thank you, Chair. Brandon Berry, planner with the City of St. Pete Beach. If we could get the PowerPoint pulled up. So the request has already been described. The applicant agent is Brandon Tecklenburg of 702 Pagway LLC. He is present today to support this case. This is an unnecessary and undue hardship variance case, and the case number is 25142. Here's an aerial of the property. It is located between 7th and 8th Avenue along Paso Grill Way. Property has a zoning of CRDEA, that is this Community Redevelopment District, 8th Avenue. It has a future land use designation of Special Planning Area 2. This is a moderate to high intensity mixed use zoning district. It allows for standalone commercial office. It allows for mixed use residential with a commercial component, as well as standalone lodging uses. The applicant is requesting a variance to Land Development Code Section 40.11(2), which prohibits driveway access from the main thoroughfare following redevelopment. There is an existing driveway access of approximately 16 feet in width that connects from the private portion of the property to Pasterville Way along the frontage. The applicant is seeking to both retain the driveway access following redevelopment that requires variance. They are also seeking an expansion to approximately 20 feet in width that is measured at the property line of that driveway, again following redevelopment. You can see here in existing conditions, this is a snippet of the survey. You can see the subject curb cut at the bottom right of the screen. The reason why this variance is required is because the property abuts an alleyway that terminates at a point at the rear of the property. It is a 10-foot alleyway per the plat. Reviewing the survey conditions, there's approximately 9 feet of usable width for a vehicle in that alleyway, and you can see that on the top left side of the screen. You can see here a request under a site plan review. This is something we discussed with the applicant. This is a potential development of the property. It is currently under review. Because this pertains to the same matter, we did bring this forward. This is the expansion part of the request. The existing drive, I mentioned here 17 feet. It's approximately 16.5 feet measured on the most recent survey. The proposed drive is approximately 20 feet in width. Again, that is measured at the property line. There is an apron flare that extends further north than the width of the driveway. You can see here an aerial of the property showing the remaining public alleyways that fan out from the alleyway that connects up with the rear of this property. There are 2 connections, one of which is obtained through a property, one of which is an actual platted alleyway. That's the one further on to the west, and both of them access 8th Avenue unencumbered. Staff reviewed this request with the applicant at the January 12th Technical Review Committee. We asked several questions: whether the applicant would be willing to forfeit any on-street parking passes to accommodate a pending use of the property. That was addressed through conditions, which I'll cover in a moment. Whether any consideration had been given to establishing easement through the adjacent property of the street, which would have required alteration of this request. That is not requested at this time. Were that to be established in the future based on the current requirements of the Land Development Code, it would require amendment to this request. And the third item was whether there was a willingness to install a landscaping buffer along the southern side of the driveway to screen the drive aisle. That is also addressed through conditions. This item was also brought to the Historic Preservation Board yesterday at a special meeting for recommendation. The board found the request did not meet hardship variance criteria number 2 or number 6, but otherwise found that the request to retain the driveway apron was sufficient to recommend approval for retention with conditions. There are 5. I will go into detail on those in just a moment. A comparison with proposed staff conditions can be found at the end of this presentation. Here's some photographs of the site showing the sign posting, showing the front of the site looking toward the alleyway, a view of the existing curb cut that is sought for retention, and it would be expanded toward the photo taker. This is showing a rear garage apartment as well as a utility building at the rear of the property. This is showing the adjacency of the existing building to the neighbor to the south, 700 Pasterville Way. This building is currently under proposal for demolition under a pending site plan. This is looking from that garage out toward the alleyway. This is looking to the west. This is another photo from the alleyway toward the garage. And another shot of the frontage looking toward the site. Staff wanted to make a few comments regarding this case. The rezoning of the subject property to CRDEA was undertaken voluntarily by a former owner when the district required alleyway access. This requirement to which the variance is sought was in place in 2018 when the rezoning was undertaken and was approved. That provides only limited support for criteria number 2 of the hardship variance criteria. However, staff does find that there are special conditions that apply to this land that do not apply to other properties in the same zoning district. Staff finds use of the alleyway for primary ingress and egress likely provides an unsafe condition that is made pursuant to criteria number 8 of the hardship variance criteria. And it's also due to the somewhat unique lack of alleyway circulation. The block between 8th and 9th Avenue does have circulation. It does have an alleyway that is only 10 feet wide, so it doesn't have a passable width within that west to east alleyway, but it does at least provide for circulation. The alleyway that abuts this property terminates into the rear of the property, so there is not that circulation through a public alleyway thoroughfare. Additionally, if a pending lodging facility redevelopment is undertaking, allowing a new low turnover use to account for significant amounts of on-street parking is contrary to what we've determined to be the district purpose and intent, which supports preservation of the existing high turnover mixed-use development pattern. Those are criteria 7 and 8 of the unnecessary and undue hardship variance criteria. The district purpose and intent places a lot of emphasis in the CRDEA on retention and support for the existing mixed-use development pattern, the businesses and the uses that currently exist along and adjacent 8th Avenue within the zoning district. Those are generally high turnover uses, commercial, restaurant, retail. A lodging facility, which is currently proposed for the redevelopment of the property, is a much lower turnover use. Retaining those on-street parking, moving the parking onto the subject property through a safe and accessible driveway access from Paso Grill Way is something that staff finds is in compliance and in support of the criteria of the hardship variance. So as I mentioned before, the Historic Preservation Board provided their input on this project yesterday. I will go through the staff conditions that were proposed with the staff report and speak to whether the Historic Preservation Board requested any modification to those criteria. Condition 1 is that addition of property to the subject zoning lot that would change the relationship of this property relative to the surrounding thoroughfares or use of the property for other than the pending request shall make the request null and void. There had been an initial lead-in sentence that provided staff justification for the subject request. The Historic Preservation Board had requested that that be removed for their recommendation, but they did agree with the null and void requirement that is in the staff column. There had been a condition recommended in the staff report for right turn only signage at the egress to the property. Should this driveway be retained, that would be installed facing Paso Grill Way. Again, egress from the driveway toward Paso Grill Way. Staff did speak with the applicant in advance of this hearing. We do support a recommended request to amend this, that if this is supported by a traffic and or safety analysis at the time of site plan issuance, staff would support that requirement should it be required at site plan issuance for whatever development ultimately takes place on this subject property. The Historic Preservation Board had reviewed this yesterday. They had requested to keep this as written without the underlined text. I will say that the underlined text in the staff column was a recent addition that followed the Historic Preservation Board meeting, so they would not have been evaluating what was underlined. Staff had requested a 3-foot wide landscaping buffer, fence, or wall with a minimum height of 5 feet along the southern side of the property abutting the neighbor at 700 Paso Grill Way. That shall be maintained or installed along the south side of the driveway. The Historic Preservation Board had requested that that be kept as written. Staff had recommended, based on the existing and the proposed conditions at the frontage of the site that would be caused by the retention of this driveway, that the owner shall forfeit 2 on-street hang tags upon redevelopment of the property to account for the inability of the city to establish 2 spaces at the property frontage following redevelopment should this driveway be retained. The Historic Preservation Board had requested that the owner forfeit all on-street hang tags upon redevelopment of the property. That's going to vary depending on what the ultimate use of this property entails. However, based on the current proposal that staff has on file for a site plan for a 17-unit lodging development, there would be approximately up to 25 hang tags allowed for this development. There had been no staff condition related to the 5th condition that the Historic Preservation Board had requested, which is that architectural rendering shall be provided for design review of future development for review by the Historic Preservation Board prior to site plan approval. That was the one new added condition that did not just represent a modification of a proposed staff condition. I did want to make a note about the subject case. There is not currently any action on the property that requires the driveway to be removed. This is a requirement of redevelopment. The property is not currently undertaking redevelopment. There has not been an issued site plan. There's no active work to develop a new use on the property. There is a site plan for a lodging development that is pending. Section 40.11 requires use of the alleyway and elimination of the driveway upon redevelopment. So I wanted to point out that if this request is denied, the driveway may remain in its current configuration until redevelopment is undertaken. If the request is approved with conditions, the conditions become effective upon redevelopment. They would need to be reflected on the site plan prior to issuance, and they would need to be provided on site prior to certificate of occupancy for the primary building that is being redeveloped. We did make a few requests for applicant testimony. The applicant did speak to all of these items at the technical review committee when their case was reviewed. They may wish to provide additional testimony to this today. We are not, as staff, asking for any additional information from the applicant, but these were the items that we had requested in the staff report and which they responded to at the technical review committee. Whether they would be willing to make any voluntary forfeiture of on-street parking passes associated with any kind of forthcoming redevelopment, the ability to shift the existing or new curb cut north to accommodate a recommended landscaping buffer along the southern property line, whether the request to retain the existing driveway only 16 feet, or whether the request is to allow the design permitted under the corresponding site plan that is currently under review. As I mentioned, that's approximately 20 feet. Although there is no code minimum when parking is not adjacent, I did want to point out that there is a staff concern with a very narrow lane width related to ingress and egress for the proposed current development. Staff is of the opinion that 20 feet would be preferable for ingress and egress at the property line. We are only looking at the depth at the property line. It can fan out from that distance, but a 16 to 17 foot width provides very limited lane widths for vehicles entering and exiting the property should future development be undertaken. So there are multiple motion options to point out to the board. Most of these are boilerplate that you see with any case. The first would be to approve the variance case for 702 Passigo Way with no conditions. We've presented two different sets of conditions, the conditions that were drafted by staff with the staff report as amended at this hearing, or those that are proposed by the Historic Preservation Board. Approval of the variance case with other conditions, whether some or all plus additional of the variance conditions that were recommended by staff or the Historic Preservation Board. You can deny the case, or you can continue the case to a future date pending submittal of additional requested information. We do have the applicant agent present. I'm happy to take any questions.
Questions for Brandon?
The alleyway in the back, that is a city, considered a city road?
It is,
Does it
correct.
have utility right-of-ways along it?
Get back to the survey. I don't believe there are any platted easements at the rear of the adjacent properties that I am aware of that would make it wider than 10 feet at any point. That 10 feet is a platted easement that's maintained as a public thoroughfare, but I don't believe there's any easements that would allow for widening of that or any recorded utility easements, at least on the plat.
Because what I was trying to determine if there were any encroachments with some of the structures that go along the alleyway, because it seems sort of irregular.
Based on the survey, I believe we measured approximately 9 feet, and that's only at specific points where there are poles and other encumbrances. So it's 9 feet in usable width at the narrowest point.
Brandon, on the front, are there utility conflicts on the expansion of this driveway based on what you were showing it appeared to be? And from my drive-by, there was lighted poles there, a light pole there.
Mm-hmm.
You just passed, well, I
You
don't know.
passed.
There's
I'm
there's
passing
a
away. This
yeah,
photo.
another picture.
Yes, and we would address that under any future redevelopment plan, either relocation or removal of that pole. That is something we would have to coordinate with Duke Energy and our Public Services Department.
At the expense of the developer.
It's typically at the expense of the developer, yes.
Brandon, understanding the redevelopment is, pending speculative at this point. In general, in Casa Grille, a lot of this size, what is required to go to the Historic Preservation Board for review? Or can you just remind us of what that process generally would look like regardless of this specific project?
So in the Paso Grill Overlay District, the CRD 8th Avenue is not part of the overlay. New development typically moves forward to the Historic Preservation Board for a design review. That is an actual action that the Historic Preservation Board undertakes. They do make recommendations, but they are able to request resubmittal based on staff comments or finding that the design doesn't comply with the ordinance and the other requirements. In the CRD 8th Avenue, currently the city does not have a mandatory design review process. This item was requested by the City Commission at their meeting 2 weeks ago for Historic Preservation Board comment prior to the Board of Adjustment, which is why that special meeting was held yesterday.
But would the site, I guess what I'm trying to understand, for the Historic Preservation Board's last condition, would the site be going forth for their review regardless, or is that condition needed in order to make sure that it?
That condition is currently needed based on pending amendments. Any new development would go forward for their review, but under the current code, it would require a special condition.
Okay, thank you.
Do we have a copy of your staff, that one page that you showed? Do we have a copy of
For the recommendation from the Historic Preservation Board?
Yes.
Yes, it should be in your packet.
and what we just received?
Yes.
Okay.
If not, I do have additional, but it should be on the top.
This is what it looks like.
And Brandon,
Oh, okay, it looks different than what was presented. You had a table, I think, then.
Correct.
We don't have that table.
As far as the table, it wouldn't be in, that is just something we've done for the PowerPoint. This was
Okay.
just,
If possible, while we're discussing this, could we get a copy of those couple of slides? Yeah, that'd be
I'll
helpful.
print those out.
As
yes.
well as the summary that you just made about the conditions. So a copy of maybe it's just a copy of your presentation.
The last two slides.
We don't need the pictures.
Member Small, did you have a question for Brandon?
and that was along the same line. The Preservation Board did not have a request for a right turn only sign, is that correct?
The Preservation Board had included that as a recommended condition. The underlined text, I'll get back to that. I will print out copies for the board. The underlined text in the second row down under the staff condition header, if supported by traffic and or safety analysis at time of site plan issuance, that is an addition after the historic board meeting that we discussed with the applicant, and I was supportive of including that in the condition if the board's amenable to that.
Very good.
Thank you, Brandon. Would the applicant please come forward?
Sorry, one more question. Maybe you touched on this and I missed it. When was the current driveway approved, and what was the process for that?
I believe based on testimony shared yesterday, the driveway is well over 50 years old. The actual current surface, I'm not sure when the last permit for that
That's
was
fine.
for, but it's been there for,
Curb cut, and the driveway access point there has been over 50 years.
I believe the applicant has a specific or an exact date. Yep.
Thank you.
Good afternoon. I'll be brief. My name is Angela Covington. I represent the applicant. With me today are Brandon Tecklenburg and Greg Murtaugh, both principals of the owner and residents of Paso Grill. We're here today on a request for a necessary and undue hardship variance to allow retention and modest expansion of the existing driveway you've seen pictures of. I want to begin by emphasizing what this case is and what it is not. Not a request for increased density, new use, or preferential treatment. The proposed lodging use is by right, and the variance relates solely to vehicular access driven by physical constraints that are peculiar to this parcel and not shared by similarly zoned properties. We appreciate the work staff and the advisory boards have put into this application, but the applicant does have concerns with some of the conditions that have come up as recently as yesterday morning. And Mr. Tecklenburg will address those in detail. I'm just here to give a high-level overview of where we are. The staff has concluded that the request satisfies the hardship criteria, is not injurious to the neighborhood, does not impair property values, and actually reduces strain on public parking resources. We agree and are prepared to accept certain limited conditions, and Mr. Tecklenburg will get into those details. I'm here if you have any questions, but just wanted to give you that overview.
Thank you.
Alleyway conditions video.
Video, yeah, right there, stop it there. Hello, good afternoon, I'm Brandon Tecklenburg, one of the owners of 702 Pasadena Way. Thank you for being here today. I'm going to start with a video presentation so we can clearly see the video of what we're trying to propose here. Hello, this video is for the hardship variance for 702 Pasadena Way.
Looks like it's just muted on the bottom there.
Hello, this video is for the hardship variance for 702 Pasadena Way. After having our meeting with the city manager and city staff, several staff members said they've never been to the property. So here is the video for you, along with the Board of Adjustment, the Historic Preservation Board, and the TRC. As we pull into the driveway, this driveway has been here for numerous decades. It was permitted in 2010 to go from cement to pavers, which was approved by the city and closed out. And the alley in question is off this north garage. And as you will see in the alley, there's numerous obstacles along with the width. So green junction box has been put in, light pole, cables running across, cables very low running, white vinyl fence from the neighbor coming out, running down, cement coming out. Per code, the alley needs to be wide by 20 feet. In places, it's anywhere from 9 feet to 10.5 feet. As we come up here, you will see another green junction box, piping, cables, other cable, light pole with cables running, coming down really low, another vinyl pole, multiple cables running here, only 9 feet wide right here, wall coming right out to the alley. You have an old school wooden barn garage, no turn radius available for emergency vehicles to be able to turn and come down this alley. You've got multiple utilities, potable water, sewer, another water right here. You've got a main water line running right off the alley right here. And as you come back, another utility. These are the boxes. And there you have it. Hopefully this is a better viewpoint for you. Thank you.
The aerials.
No, just the close-ups in the alley. Thank you. Thanks. All right, and then I'm going to show you some close-up photos of the alley. There we go. So you have the gas at the bottom sticking out, white vinyl fence, cement ground, green junction box. You've got 4 total power poles, cables coming from the ground up. Wall going all the way. That's Evander Preston's building right there. Garage barn. And all the utilities. All right. Thank you. Thanks, Brandon. All right. When we purchased the property in June of 2022, I had multiple meetings with the city staff to know what I'm allowed to do at the property, what I can do, what I can't do. I asked every question known that I could come up with. At no time was this ever brought up that if I ever built on my property, that the driveway that's been there since 1925 would cease to be the primary driveway and that the alley would be the primary. That was brought to my attention in October, the third week of October of this past year, 25. And for the last 3 months, we have been working diligently on resolving this matter. And I'm here today just to be able to keep our driveway as primary and not have the alley. And then with that said, there are a couple of things I wanted to point out. Kristen, were you able to get the numbers on the emails that came in? Did you have a...
Madam Chair, if that's okay? Okay, so out of the total 53 emails, 36 were in support, 9 were an objection, and 8 of them either had questions, comments related to the project, or other concerns not specifically related to the variance request.
Thank you.
Thank you. So we do have the support by the local residents. I also want to let you know, more importantly, I have the support of local business owners on 8th Avenue. In those emails, the Seahorse owners, Paradiso, Kathy Young Realty, and La Tortuga. The owner of Berkeley Club is here, and he's given me his verbal approval as well and support. So it's just not residents in St. Pete Beach or Pasquarel, it's also the owners on 8th Avenue. To discuss a couple things that were brought up in the historic preservation meeting, there was 5 recommendations to myself, my partner. The recommendations are more of a way to lower the value of our home, or I should say our property. It is, when I bought this property, we paid $3.9 million. I would have never have bought this property for $3.9 million if I knew the alley would ever be the driveway of the property. Again, we did our due diligence and this was never brought up. So the first recommendation by the Historic Preservation Board yesterday was about acquiring more property. I am not acquiring more property to add on to this property. So I just wanted to be transparent. We are not acquiring any more property. The next item was brought up about the city, and then it was discussed at the Historic Preservation Board about a right turn only coming out of the driveway, and would I accept that? At the meeting, immediately there was multiple board members that said, you can't do that, that's a double yellow line. I am 49 years old. I forgot what I learned in traffic school when I was a student, and so I did a little research, and basically this is the Florida statute 316.087. Double yellow lines prohibit passing, not left turn into or out of a driveway. So I discussed that with Brandon this morning, and he said he is deferring that for the future. So it's not part of the recommendation here today. The next thing, landscape. So I have photos right now, and I'd love to show you of the current landscape, and then I'll talk about the fence.
Brandon, while you're pulling up the photos, just so we can not forget and go back to things, for the right turn only component, the city's recommendation added language that said, if supported by traffic and or safety analysis at the time of plan issuance. Are you in support of that language?
Yes, that was not the language yesterday, but it was the language today. Yes. So I just wanted to let everybody know, because we sent the video, we just watched the video and pictures of the alley. But currently, this is, the first picture is of the west fence. That's all Birds of Paradise. You can look at the property. I'll get to the north side here in a second, but there's plenty of foliage on the property. This is our north fence, and that is shared with La Tortuga on the other side. It runs northeast, That's basically northeast right there, and it runs all the way to northwest. The in question, I think, is the protection, privacy of our property with the property to the south, which is 700 Paso Grill Way. Right now, there is a 6-foot fence there. When we saw the photos today, there was a couple missing fence panels. I don't know if it's a sign or not, but when I left, Hage Fence 16 months later is at my property right now fixing the fence. So I signed that contract with them in October of 2024. So there is a 6-foot high fence all the way down. It says in the recommendations, landscape, fence, or wall, and I agree with that. I think definitely if I retain the property, that fence will always stay. The driveway paver goes all the way to the fence right now. Now going on to parking passes. All right, so when I had a TRC hearing, the first item, when we brought up the parking passes, it was asked of me if I would forfeit 17 parking passes. I said at that meeting, no. Then from there, yesterday was new to me. The city asked if they brought up the number 2. I didn't get to speak on that. The historic board went right ahead and put a recommendation in that I would lose all 17 parking passes, and that's their recommendation. And I think the best way to describe that is I, again, did my due diligence. I asked what I was allowed to have at this property if I purchased it. And at that time, I was told I would get there are 17 lodging units max at 1.5 parking passes per unit. I don't think there's anybody here, and if there is, I'd love to have a discussion. I don't think there's anybody here that would spend $3.9 million and promised 1.5 parking passes per unit. And then when there is a possible building that's going to be possibly done, then all of a sudden I'm told to give it all back. So it's fine when I bought it, when there was nothing there, but now all of a sudden I'm asked to give it all up. That would diminish any chance of a sale. The value of the property would drop. I'm not here to give up any parking passes at this time. We can definitely communicate and talk about that, but I don't think there's anybody here who has a house or a commercial property, and if they were told, hey, I need you to give up your parking passes if you want to be able to use your driveway. And that's what we're here for today, a driveway. I know there's people that are going to be talking about a building. That building was brought up back in July. So I'm here strictly on the driveway. Finally, the Paso Grill Historic Preservation Board. On the 5th item, they asked if they could have input on the property. If anything was ever built, basically their opinion of what they think a building should look like on or close to 8th Avenue. I would like to point out that the Historic Preservation Board does not have a codified guidelines. There's no documents. It is basically their opinion, but there's no documents or codified guidelines ever set by the City of St. Pete Beach or the Historic Preservation Board on what they are allowed to do. With that said, I would like to watch a video here that we snapshotted from the Historic Preservation Board meeting yesterday. This will be at 1 hour, 40 minutes, 30 seconds to 1 hour, 43 minutes, 20 seconds, where the Historic Board
and all the
chair tells everybody that.
behind the CRD
Right.
was never put into enacted. Everything's changed and suddenly became a situation where
Chairman, let's let
really
them
hear
get
it
through
very
his 3 minutes, please.
Excuse me, Brandon, is it possible to restart and increase the volume of this video?
At this point today,
Thank you.
you're not prepared to.
Is that a home a little bit.
So many loopholes and all the intent
How about
behind
the
the CRD
microphone? Maybe near.
was never put into enacted. Everything's changed and suddenly it became an area, a situation.
Chairman, let's let them get through his 3 minutes, please.
Maybe it would be nice to take, at this point today, you're not prepared to tell people that they can't have something. I'm not on anybody's side. I've been here. All I do is redevelop old. I've never built something new. I've always redeveloped something old. But basically, I think you're, as of today, somebody is asking you something that you probably should say yes to, but then take from today as a date to remember that we can make Pass-Grille better by giving input on what to choose and say these are items that the historic board likes on design. And if that hasn't been done yet, it would be a great time to add that to it, if it could be.
So we've been doing it, we've been putting it together for 3 years, Dave.
I would say that there's probably a way you could find a way to be more mainstream on it. But today, somebody's asking you something that you're almost obligated to answer, if that answers the question.
Any other comments? Comments? Somebody up there, I don't know if you put your name in or not.
You have to come up to the microphone and fill out a card. You can fill out the card after.
Just state your name and address for the record, please.
My name is Marty Nora, 555 Gulf Way, St. Pete Beach. I have property on 8th Avenue, actually directly behind the proposed site we're talking about. And I appreciate what Brandon showed on the alley. Yeah, the alley, okay. My confusion is there's other properties that have an 8th Avenue. If we have to lose some parking spots, that just concerns me down the road because the store is there. So if this variance goes through, it doesn't go through, I just want to make sure with the properties that's being proposed, if nothing gets built there, then whoa, I really don't want that alley or the driveway expanded. If things go through, and plus, I do like the fact that things are historic, because the properties we have on 8th are historic. Built in 1915, 1930, so I would appreciate to keep the historicability on that property. And if nothing goes through, then I don't really want that driveway expanded. Otherwise, and it's a tough decision, but thank you.
Thank you.
It would have been great if I played you the right clip. Do we have the right clip?
I can get it pulled up if you want.
Okay, yeah, when you're ready, just let me know.
If you also wanted to just summarize the point that you're
Sure.
demonstrating.
So,
I believe we all watched.
Yeah, I got you. Yeah, so the Historic Preservation Board Chair just said that there are no guidelines. There are no guidelines to basically tell us what color, what look is of a property. And with that, it's really been, and also he verbally said that this will ruin Pass-Grille if a building's allowed to be there. So I just wanted to take a moment to look at the current modern properties, because that's what was brought up, was this will be a horrible modern building. So these are the current modern properties that just are now moving into here in Pass-Grille.
Excuse me, Brandon, if I may. I
Yeah.
believe we're here to talk about the driveway
Yes.
and not the
Okay,
building.
okay.
This is irrelevant.
Thank you. All right, thank you. All right, I just wanted to, that was number 5. So that's why, I understand you say it's irrelevant, but to us, number 5 was, they wanted, their take on what a building should look like. Yes, and everybody has their own opinion. All righty, great. So.
We
yep.
would only care about that if you expect there's a future variance request in this plan.
Yeah, yes, there's no variance. I'm not,
Additional variances that you expect to be requested.
I agree with you.
Then please share that with us.
No.
Otherwise, we do not
No.
need to know color, shape, size for
Great.
that.
No variance whatsoever.
have to work
I'm
on.
just here for the hardship driveway over the alley. Great. I'm here to answer any questions that the board might have.
Well, discussion about the alleyway is pretty much moot anyway. Nobody thinks that that alleyway can be used for anything. I mean, it's barely usable now. I'm very familiar with it. If you drive into it, you have to back out of it because you cannot turn around in there. It's one of the worst, most narrow alleys in all of Paso Grill. So that, even talking about that is silly. Of course, that's not usable. So the question is going to be, can you get a driveway to go into where your proposed hotel is going to be with enough buffer, I guess, to the south side to satisfy the concerns of the people that are here because this is their homes that are right behind it?
When you say south side, the driveway where it is currently,
going east to west.
yes, the driveway would just be widened to the north. It would not affect any neighbor, because it's just going to go north into the property.
No, I understand
Yeah.
that. But the question is about, well, we'll let people
Yeah,
talk about it.
let's wait and hear from the public. Any other questions for Brandon at this time?
Yes, so with the redevelopment, how many parking spaces are you expecting to offer?
Okay, so I'm not developing the property. So I'm just,
Your site plan, do
sure.
you have a called-out number of spaces?
Sure. So there was an interested buyer in the summer. They submitted a drawing, and they had parking underneath the building.
Yes.
Correct.
Is that not true?
I'm asking the question because I
Yeah,
believe your
no.
request for a driveway expansion is based on a site plan. So with
Yep.
a site plan, either that or we probably don't
Yeah.
need to look at this right now. We could continue it
Sure.
until there's an actual plan to dictate whether or not you need 20 or 10 or 25 or, that's why I think it's relevant and we would want to understand
Yeah.
that.
So when I spoke with Brandon Berry, I just wanted to be able to have the driveway as the primary over the alley. And then Brandon and I talked, and he said, hey, why don't we add in what possibly could be a wider driveway so that they can look at that? So kind of like not having to come back again. So it's basically here, this is the proposal. And so it's kind of like a 2-for-1. Look at it now. You can see what could be possible just to go up 3 feet. But as far as I'm not building anything. I'm just the owner of the property, and I'm trying to think ahead because I'm on my heels, because for 4 years I didn't know this problem existed. So what I'm trying to do is just be able to, if I want to do something down the road, or if we do sell it, I want that everybody knows that the primary driveway is the driveway that's been there for almost 100 years.
Okay, so we could just be discussing the current driveway, leaving it as is today, and approving that as a variance independent of the widening of it, and you would be fine with that?
Yes.
Okay.
Yes.
Thank you.
Yep.
Any other questions? for Brandon?
That answers mine.
Thank you.
Okay. And then, this is my first time. If there's any public comment, I just would like the opportunity to respond. Thank you.
Madam Chair, before you leave the mic, did you have any questions regarding any of the disclosures that were made by the members? They mentioned that they have gone by the property. Are you satisfied that they have open minds and they have a clear understanding of it?
There was a day that we scheduled for city staff to go out to the property. I opened it up.
I'm referring to the disclosures that were made at the beginning of the meeting, the ex parte.
Oh, yes.
Did you have any other questions to ask them about it?
I do not have any questions at this time.
Thank you.
Hey, thank you. Appreciate it.
All right, City Clerk, public comment?
Eric Abel?
Hi, Eric Abel with La Tortuga, 102 8th Avenue. Really just coming to support the petition. Seems reasonable to not have to go through the alleyway. Really didn't have much else to add, but we're obviously next door neighbors and appreciate, the development or whatever happens there, but the alleyway definitely not being something that was usable.
Thank you.
Thank you.
Tina Douglas?
Robert Douglas, 2811 Paso Grill Way. I think I have misunderstood the purpose of this hearing today. My recommendation, based upon what I've heard, that no action be taken today. The driveway is there. If someone buys it and wants to have a single-family home, they're entitled to use that driveway. If somebody wants to build, incredibly enough, 17 units on this little piece of property, then that's a separate issue that should be addressed at the time that that plan is presented to the board. So I think there should be no action taken until a comprehensive site plan is presented to the board. Thank you.
Can you make a comment about that? The zoning was changed in 2018 from ROR to CRDEA, which precludes it from building a residence on it right now, and the driveway can't be used.
Correct.
At all. And so when that was purchased, I'm surprised that wasn't known, that right was forfeited once that transition was made.
We'll have board discussion after public comment, but I appreciate the feedback.
Jay Anderson?
Jay Anderson, 202 Pasco Way. What you're being presented to today is a request for a variance for a vacant piece of land. I don't see the hardship. It's a vacant piece of land. Why do you need to widen the driveway? Should, again, as was said, if a development comes up, let those people ask for that variance or that need that they might establish. But right now, why are you going to grant a variance to a vacant piece of land? There's no hardship.
Thank you.
Mary Jo Miklich?
Good afternoon. My name is Mary Jo Miklich, and I have 801 Gulf Way, the Keystone Motel. I'm located in historic Paso Grill, and I have the pleasure of interacting with many guests every day and welcoming newcomers to the area. With that being said, one thing I often hear is how much they enjoy the quaint, local charm that we have there in Paso Grill. We have a wonderful community. The aesthetics of our community is what draws residents and visitors alike. Many guests and those discovering our community for the first time share their gratitude, and our community has not become like so many in the beach towns north of us. When properties are bought and sold, they are done so with an understanding of the community and what's permitted. Ample research is done prior to purchasing to make sound business decisions. Oversight in a purchase of a property does not constitute a reason to have ordinances and codes changed to allow for personal gain. Codes are written and placed for a reason, and allowing the bending of one creates a precedent of what would be allowed in the future. This is why I request that you do not approve the variance requested for the property located at 702 Paso Grill Way. I want to thank you for your time and efforts in protecting the community we all cherish. Thank you very much.
Eileen Gunther?
Eileen Gunther, 111 10th Avenue. If a variance is granted today, and I don't know if you're going to continue it or if you are going to make a decision today, I do have a very serious concern about the parking passes. I was very pleased with the fact that the one design I watched, I don't know what meeting it was at, but they presented their building design, and it had 17 units and 17 parking spots underneath the building. And I thought, well, that was great. I had no idea that in addition to that, they were supposed to also get 1.5 parking passes per unit, which I find, for that area, I can't even believe that. I could understand that the city telling them that when they, when they were asking the questions about their property, that they would get 1.5 parking spaces, if in fact they were just going to put a building up and it wasn't going to have any parking. So the city is saying to them, okay, fine, we're going to provide you passes, et cetera. But if they have on-site parking, that should be the end of it. They should not try to take the parking into the neighborhood. I live on 10th Avenue. I am not allowed to have a curb cut I can't have a driveway. There are no driveways on 10th Avenue, and there never will be. So I have to park in the street, and my alley is exactly the same as the alley that everyone is saying that they cannot use. I have a 10-foot alley, and all the way down the alley are the electric poles to take it to 9. So I have a 9-foot alley that I have to navigate my parking through, and a turn that's basically impossible to make. It's a 3 or a 5-point turn to get out of my parking space in the back. I'm saying that because when they get 17 units, 16 units, whatever they're going to put on there, and they have enough spaces on site, they're going to then create a hardship for me. I already share this with the shuffleboard court, the museum, all the other parking that's on 10th Avenue that I have to navigate my spots for. So if you do grant this variance today, I would like you to grant it with that condition, with the condition that they do vacate or they're not given any additional parking passes for those units. The other thing is that the parking that we have challenged with on 10th Avenue, it is a challenge, but I know that everyone is going to leave in 2 or 3 hours. They're there for the sunset, they're there for dinner, they're there to play shuffleboard, whatever, they're there to shop. When they give that second parking pass to whoever is going to build there, those people probably came as 2 different couples with 2 different cars. So they're going to park one car under the building, and then that second car, they're going to say, here's a parking pass, go find a place to park, and they're going to put it there, and it's going to stay in that spot for days or a week. You see what I'm saying? It's not going to turn over. So I literally could have, parking on 10th Avenue in front of my house. I would never be able to park there. So I'd just like you to consider that if you really are going to go ahead and not continue this today. Thank you.
Dave Feinberg?
Good afternoon, Dave Feinberg, 1407 Passigrove Way. I'm here to support the variance for the driveway because it is a vacant piece of property, and what I felt was not right was the alley being the front, which I think you've all made it clear it's hard to make it accessible. So for them to be able to sell their property, I just support the front being what the front has always been, and the back can be whatever you can use it for. But it just makes sense that the front is 702 Passigrove Way. It's got it there already with a curb cut. And I think if you come up with a design and you need to widen it 3 feet, that's something you could probably work on. We had owned that property before. That driveway has been there a long, long time. I can't say 100 years, but I'll bet you at least 50 or more. But anyway, thank you. I just wanted to say I supported it simply for that reason.
Thank you.
Thank you.
Jeff Catanzarita?
Hello, my name is Jeff Catanzarita. I live at 109 7th Avenue, Passigrove. My great-grandfather built a house back in the 20s. My grandparents have been there, parents have been there. Now I live there. I sent in a letter to the board, to every one of you on my comments, so please read them if you haven't, because that'll encompass a little more. At this time, I can't support the variance because it seems like we're in a kind of upside-down world. I understand it's a hardship, but the hardship is the 3 people that live there, those 3 houses. That if they're going to build something, at the same time they're saying they're not going to build something, but we're talking about 17 parking passes. It doesn't make sense. So obviously something commercial is going to go there. It's going to go up. There's going to be some, who knows what they're going to, I only really care about what goes on top of the building personally. I mean, I don't care if they build a skyscraper there, but if they're going to have rock bands up there, kids up there, or rentals up there, not supervised drinking and partying. I live right behind Shadrack's. I already tolerate a lot of noise. That's fine. But to keep piling on, and it's going to lower our values. of our homes, especially lot 15, 14, 13, and 12 that are run along that alley. So I'm not opposed to even the building, but until it's a comprehensive site plan, I don't think this variance should be granted. And I agree with the gentleman who said it's an empty lot, it doesn't need a variance, and that's how I feel about it. Thank you.
Marty Nora.
Hello, my name is Marty Nora, 555 Gulf Way. I'm the owner of 104. Brandon, thanks for doing it. Paradiso and the realty shop, they were renters from me. Great renters. I have renters upstairs. So parking is an issue, yes. And that alley, he didn't show pictures. I actually have dents in that white fence. So it is a concern, very difficult to use. So I appreciate the consideration that that alley be not taken into consideration. As far as for the variance goes, I highly recommend or like to work with the Historical Society because the properties that I own and other people on 8th Ave is of historic value to us. So until I really know what's going on there, I do not want to lose any more parking spots than are necessary. I really take in consideration all that you do, and I like to consider 8th Avenue historic. So I am still kind of confused at what's happening. But if it's necessary for a variance, if something gets approved there and moves, great. If there's really nothing known what's going there yet, I guess I'd like to keep the property the way it is too. Thank you for your time.
Teresa Shefstad.
Thank you. Teresa Shefstad, 555 Gulf Way. Thank you for your time. We all know that codes exist for a reason. In this case, we have a code that can, if it gets a variance granted, will change the character of Paso Grill with the redevelopment that's being considered. With all due respect on the count that was given today, that was disingenuous to say how many support this variance or not, because there's a consequence to what will happen with this variance. And for months, I think that all of you and the commissioners and other members have received a lot of requests not to approve the development that can occur with granting this variance. In fact, St. Pete Vibe, you all were sent the copy, had about 300 responses against the type of development that can occur if you approve this variance. There were maybe 3 or 4 that said yes. So to use a count today that's talking about the driveway is disingenuous because it's the consequence of what can be developed. And they should have also been submitted, provided time to respond to what the Historical Preservation Board recommended, which was very thoughtful. And I hope that each of you all, I know you don't have much time, but I really recommend that you go back and watch what occurred at the meeting to hear all of the perspectives, especially those of the community. I've sent numerous communications to the city, have gotten no responses about how it's not 17 units, it's 34. They're going to put 2 rooms in each unit. And we were told in a Zoom meeting by the developer, oh, well, they're only going to drive 1 vehicle. And now we're talking about 34 parking passes. Nobody has responded from the city about the status of the environmental protection consent order we're under. Are we still under that order? So I just want to ask all of you to realize that this decision today has consequences and that you look at it at a broad base. We have people that bought this property who claim they're investors. They should know what they're buying, buyer beware, and then suddenly they claim innocence. So please consider how this impacts our community and the consequences of your decision. Thank you.
Danielle Daschel.
Hi, good afternoon. Danielle DeShiel. I own 111 8th Avenue, right there in the heart of Paso Grill. 702 Paso Grill Way was requested to be changed actually by Mr. Feinberg from ROR to CRDEA in July of 2017. It feels like yesterday. The reality is it was 9 years ago. We all look the same and feel the same, I'm sure. The current owners bought this property 4 years ago. A lot happens in 4 years. If this were truly an unnecessary and undue hardship, it should have been immediately addressed, either prior to purchasing or immediately after. There is a benefit that they currently have of having both the ROR and the CRDEA zoning because they have both. They have the beauty part of the driveway of the residential component. They have the alley access of the commercial component. This request should not be approved as a result of an inconvenience, a lack of due diligence, especially 4 years later. Thank you for your time. Thank you for hearing us out. And here's hoping we can come to a good resolution.
That's all the cards I have.
Thank you.
Bill Lowry.
Good afternoon. Bill Lowry, 2405 Pasquarel Way. I meant to come up just to say, I'm the chairman of the Historic Board, and if you had any questions, I would be available. But after I heard the presentation, I think we need to speak to clarify a few issues. I hope you all did have an opportunity to watch the whole thing, because those things are taken out of context. One thing you got to keep in mind is that this property, when the CRD was created, was zoned ROR. It was intentionally left out of the original CRD. Why? Probably because of this alley issue. Okay, because this piece of property is unique to everything else in the CRD that was originally in there. So CRD came into effect, in which the intent was to maintain the historic nature, and people talk about certain things. This is all in the historic district. The Historic Board has an input on the whole historic district, not just the parts that are under the overlay. So the question would be, and if the CRD Division 40, you can read it, it's very small, and it says in there, if you abut an alley, you shall use an alley. So the question would be, after that was put in effect in 2012, why in 2018 was it asked to be rezoned, knowing how crappy that alley was? Knowing that you'd have to use that alley. And the answer is because ROR, you only get 6 units in a bed and breakfast. CRD, you get, in this case, 17 units in a temporary lodging, different kind of facility. So commercially, it made sense to do that. It was granted, okay. So the question would be, why would you rezone it knowing that you had to use the alley, which was in bad shape? So how has this issue been created? By it being rezoned. That lot is perfect for ROR. When they talk about the driveway, yes, the driveway was there. It's always been zoned ROR. And so the question is now, they want to have you give them a variance that essentially they can sell to a developer. They're non-conforming right now. They can use that property with that driveway for 50 years, for 100 years. Look at the statutes. They're non-conforming. They're okay just the way they are. But when they want to change it and tear everything down, for example, those pictures of the landscaping you saw, that's all going to be torn down for a building, for a development. So that's irrelevant. That's why at the meeting we had, we came up with what seemed to be a pretty good solution to give them what they want in a way, even though they didn't do their due diligence, they didn't read this stuff, but for whatever reason, the city granted that back 10 years ago. And so we're just asking for an opportunity to look at the project, to see how it fits in, to have discussions about the project, to have a platform where the citizens can give input.
Understood. Thank you so much.
Thank you so much.
We're welcome to hear from you, but please keep it brief.
I'll be quick. Thank you, everybody, for your public comment. I appreciate it. For Mr. Robert Douglas and Jay Anderson, wanted to be very clear, this is a hardship variance. I received a letter from the city manager, third week of October 25, that I could not be able to use my driveway and that I would have to go through this process to be able, if I wanted to sell my property. We were under contract at the time. We were under due diligence. We were supposed to, there was different sets of dates that we were going to have to close, different things. So when that letter came in at the third week of October, I met with city staff. I asked, what is the right thing to do to move forward? And the only way to be able to move forward was to go to Historic Preservation Board meeting in December. It was brought up again in January, then to a commission meeting, then to the Historic Board yesterday, and now we're here. So I just wanted to let the two gentlemen know that I have to be here to be able to have the driveway for if I ever wanted to personally build anything, or if I ever wanted to sell it to somebody who wants to, because regardless if it's sold now, or if I build, or 10 years from now, this will always be an issue. The next thing I wanted to bring up, the owners, mother and daughter, Mary Jo and Danielle, they are the owners of the Keystone Motel. Their family owns the Hurricane Restaurant, and their family also owns 804 Paso Grill Way. I appreciate them coming up here, but they have a personal and professional conflict with my property. So, and I get it. They're in the rental business. I'm in the rental business. I'm a good neighbor. 804 just got passed. I'm happy for it. I want a restaurant in Paso Grill. We've got about 6, 7 vacant lots in downtown district of Paso Grill, and I want restaurants, shops, bars. I want that for our community after the hurricane. Next, 10th Avenue owner, she just said that about the parking passes. And I want to make it very clear here. It's illegal to be required to relinquish any of my parking pass permits. So this is very serious. That's my property rights. Moving on to 555 Gulf Way, she brought up the parking passes. And I would say this for 555 Gulf Way, because I did my research. They have parking passes for each of their condos. Would she and everybody in 555 Gulf Way give up their street parking? I doubt they will. So what's good for somebody all of a sudden is not good for me. There's properties from 1st Avenue to 32nd Avenue that are condo buildings. There's 8 of them. They all have parking on the street. I don't think any of them have ever had to come up here and have to fight for their parking passes for their property. To finish off, I think I covered all the residents that came up and spoke. I appreciate them. I love all different views. Again, this is my property. It was for sale for 2 years. Anybody could have came along and purchased the property. And the last couple people talked about that I failed to do my due diligence. This guy is awesome. His name's Brandon Berry. I did a Zoom meeting with him. I met him in person twice. We went over everything on this property. So they can come up here after everything's happened and say I didn't do my due diligence. I did. We covered everything. I have pages and pages of work. So I appreciate your time. Again, if there's any questions, I'm here to answer them.
Thank you. We'll now close the public comment and open for board discussion.
Well, there
It's
is,
really important before we commend is to, again, stay focused on what this case is and what it's not. I completely appreciate the passion for Paso Grill. This is a big project that will have a lot of impact down the road, and there will be lots more discussion about what that future stages could look like. But our duty as a board today is to understand the case at hand for the driveway.
there is no project right now.
Well,
There is no project, correct?
there's a site,
There's a
a
site.
proposed
But there is
site
no
plan.
project,
Yeah.
there is no hotel, actually. This is all just
It's-
theoretical.
Correct.
Randy,
Speculative.
Can I have you come up just to clarify something? Because I do think that this does feel a little confusing to me. Even in the zoning table that was in the packet, it's talking about lodging units permitted. And I would think personally right now, and looking at this case that has nothing to do with this discussion.
Right.
It's information, but to me, it wouldn't be something I need to think about as far as this variance. But that's one thing I'd like for you to clarify. The second is, the 16-foot driveway width that, and just driveway that's associated with this property. I see that it denotes an existing nonconformity, so that in and of itself, with the association to this property, requires a variance to, or does not. Please clarify that part too.
So what was stated earlier is correct. Based on the current use, the existing use of the property, that driveway can be maintained, it can remain. It is the association with the pending site plan that we have in-house for a new development that the driveway is required to be removed. To my understanding, that's why that letter was sent earlier or late last year. With the reason, and I understand that could be seen as superfluous information, but this is being brought forward based on some pending development that requires this driveway to either be retained or expanded. We went with 20 feet because that is what is proposed under the pending site plan that we have under review at this time. The intent was to not bring this forward for the retention of the existing driveway and then have to bring it back again for an expansion, because we know what, based on the site plan that we are currently reviewing, what the required driveway width is going to be.
Okay, this seems like we are getting a cart in front of the horse,
Yeah.
because I am also hearing from the owner of the property that he has no intention to redevelop, but instead to sell. And therefore, if the site plan is not something that would be developed, I'm just struggling with maybe why we're gonna have to look at this case. If the current driveway in its existence can be maintained with the current property as a nonconformity, that this really just comes to bear when it becomes another developed piece of property, correct?
We have a development application in place that has not been withdrawn at this time, so we have statutory guidelines or
Okay.
timelines.
So in association with the development, what did you just call it? You have
We have a statutory timeline to review development applications once they've been applied
development
for.
application.
Yes.
Thank you. So this is in alignment with this development application.
Yes.
Even though this property hasn't sold.
Okay.
You still have that.
We do have a pending application in-house for development, yes.
Okay, thank you. That's helpful. So, I mean, based on that, my current view is that this is maintain the current driveway in alignment with its development application and the condition that they maintain the buffer. And no variance beyond what they currently have. I do see the criteria 8 as being met in terms of unsafe kind of difficulty with the zigs and the zags behind these buildings, and the utilities. That's what I'm looking at, and based on my site experience and seeing the video.
It seems to me we should continue this until we see what's going to happen on that property, because right now we don't even know what's going to be there. How big it's going to be. Is it 17? Is it 34? Is it not going to be a hotel? Nobody knows for sure. So
I'm just hearing, because of the development application and timeline, that we're responding to the driveway.
It's a commercial property that will be developed, and we know that the back alleyway is not usable, it's not safe. So the only way to ever safely enter this property is going to be through a driveway. So I think there is a very logical hardship and reason to package that formally together to enable it to be a usable site.
Yep.
I don't think there's any reason to make the driveway different than it is today, because to your point, we don't know what the site's going to
Right.
be. We don't know if there's any reason
Right.
for that. We don't know if cars are going to be going in and out. Brandon, we're not going to take any additional comments at this
okay.
point. Thank you. But I do believe that there's a case to be made that the existing driveway should be packaged in a usable fashion for them.
just leave things as they are until.
I was going to say, but I don't think at this time, because we really don't know what's going to be
Right.
on that property. It just seems like, yeah, the cart is before the horse on this.
But nobody's going to be able to move forward in developing that site responsibly without knowing that they're going to be economically able to maintain it.
Right, but, we're also talking about the vehicle traffic going on Paso Grill Way and what size that driveway might need to be, and I don't think we're prepared to answer those questions right now.
I agree.
Because we really don't know what's going to be built there.
But would that preclude us from at least being able to maintain it the way it is in conjunction with the current status of a commercial property?
Well, it can stay the way it is as long as they don't do any modifications, but, I mean, you can't build any, like a residential unit on there right now because the zoning was changed
Exactly.
to CRD. So it can continue to be used as it is. They can use the driveway as it is right now. And then when the time comes, when they do a commercial development, that would be the appropriate time for us to look at, a variance for the driveway and determine, what would be the appropriate size and safety and so on for Paso Grill Way.
Is your thought that the property is usable as it is today? Like,
Well, I mean, it's
For
usable
what?
as
We
a
don't-
rental property right now. That's how it's being used. But we're talking about some large commercial development, and I just don't know what that is. It might be what they're looking at now. It might be something else. They haven't sold the property, so we really don't know. And we're asking to give a variance, which really it's a financial hardship right now. It's not any other type of a hardship because we don't know what's going there.
Yeah, no, I just agree with that. I think it should be a package, honestly.
I agree with that too. It's too early for us to be making this.
Don't know what it's gonna be. If they wanna change the zoning on it and it was a single house, would we be having this discussion at all? No.
Yeah,
It's-
we would actually. We would still have to have it because it's non-conforming for any development, is what I'm understanding. Correct me if I'm wrong.
If it was ROR, they could.
If there's any development that's done on the property, then the variance for the driveway to be maintained is required. Is that correct, Brandon? Or they'd have to shift back to an alleyway-only access.
Correct, any redevelopment of the property.
Development
Correct.
whatsoever.
That's correct, yes.
Brandon, you reviewed this case and the criteria that are needed to be met. Can you remind us why you felt they were properly meeting the criteria needed?
I do feel that there's a special circumstance for this property that's not shared among others in the same zoning district. I do believe they face a hardship because of that. I don't believe that there's specifically related to this specific case, the actual variance that's being requested, a purely financial basis. I do believe it's a hardship of the land due to the location. And there were other challenges, the alignment in condition 8 with the purpose and intent of the district by providing safe and accessible parking on the property is something that I do feel that supports the district purpose and intent, which is largely the intent of the 8th Avenue zoning district, allowing for the support for the existing mixed-use characters. That was part of my basis.
And that's based off your expert opinion.
Correct, yes.
So I think that's important for us to consider as well, as we have our staff that's reviewing these cases based off the criteria that's in front of us. And they are telling us that their expert advice is that there is a hardship being faced in this current state.
I think I understand that. As I said, I don't know what's going there. And it's hard to have that discussion when you really don't know what they're going to be building. And that's the concern that I have.
Yep, understood. And I think where I'm at is the use of the alleyway would suggest that it meets the unsafe condition for entering and exiting that property. Just to be able to have development take place would need us to approve a variance to allow them to maintain their driveway on Paso Grill Way as 702 Paso Grill Way. So to me, it's a whole different conversation about what they're doing, but the fact that they're, in order to develop anything, need to have the declared variance approved for a driveway access.
Why does it need, the driveway is already there. You're saying there needs to be
For
something?
any development, they have to have a variance
Because
approved.
it's a non-conforming right now. So for the property to, nobody wants the property to stay the way it is.
Right,
And so for anything to happen, the driveway has to come into conformity, which needs a variance to do that. And so today, we would have the opportunity to simply leave the driveway as it is, but bring it into conformity. And then the project continues, and what that looks like and everything will have full review. And
Later.
Later.
Yeah.
Yeah.
So we have to give them the variance just to maintain it the way it is, basically.
In order to bring it into conformity.
Formative, okay.
I don't think if we're looking back at the conditions that were put forward by both the city and the historic board, in my opinion, most of those are irrelevant and should be addressed at the point of developing the plan and the site in terms of parking and, design and all of that. Like, I think I would like us to stay completely focused on the driveway, bringing into conformity with the property.
All right, well, I'll attempt to make a motion unless there's other discussion. I'm going to make a motion that case number 24142, 702 Passive Girl Way, that we approve the maintaining of the current driveway with the condition that there will be a buffer of either the landscaping, the fence, or the wall maintained and installed on the south border of that driveway at all times.
We have a motion. Do we have a second?
I'll second that.
Roll call, please.
May I ask for clarification? So when you say to approve or maintain the current driveway, is that, so the alleyway is out?
Yes.
We're talking about the variance of approving the driveway. I'm sorry, I don't know what you're asking me to clarify.
So my understanding is that there are two requests embedded in this variance request. One is to allow them to use the existing driveway, which is, I think, what you're saying.
Yes.
And not require them to use the alleyway.
Correct.
Because the code requires that now. So you're
Okay.
going to give them a variance to not require them to do the alley and use the existing as the main entrance into the property.
Has to be the only, you can't, that alley is.
Correct. Okay, thank you for the clarification. And then there is nothing in the motion regarding expanding it.
Correct.
Thank you.
So we had a motion and a second.
Yes.
Roll call, please.
Member Core?
Yes.
Vice Chair Garshaw?
Yes.
Member Small?
Yes.
Member Schmidt?
Yes.
Chair Chase?
Yes.
Motion carries.
Moving on to second case for today, case number 25145, 2814 Passive Girl Way. This is a practical difficulty variance. Thank you all for your time. We can give a moment for the room to. If we could take all conversation out of the room, please, so we can continue today's meeting.
Herding cats.
All right, Brandon, thank you.
This is a necessary and undue hardship variance, case number 25145 for the property address of 2814 Passive Girl Way. Tom Pressman of Pressman and Associates Incorporated for Matt Foster requests a variance to construct a 6-foot fence wall within the 10-foot required front setback along the Sunset Way frontage of the double frontage property, where fences and walls may not exceed 4 feet in height. The request is made pursuant to Land Development Code Section 6.15 and 20.20. Here's an aerial of the property. It's located on the west side of Passive Girl Way, just south of 29th Avenue. There is a vacant parcel between 29th Avenue and the subject property. Sunset Way, which is a road, is to the west of the property. You can see on the zoning map, this has a zoning designation of RU2 Passive Girl overlay. This property did go through the design review requirements with the Historic Preservation Board. So we don't see many of these in St. Pete Beach. There are a handful between 37th Avenue and 34th Avenue on the west side, adjacent Gulf Boulevard and El Centro. The remainder are primarily in Paso Grill, just south of 32nd, as well as between 27th and 30th Avenue. Properties in this area include this lot are defined as through lots, which are lots that are have opposite sides of the lot, each containing frontage on a street. These are defined in our land development code as shown on the screen. Interior through lots contain 2 side yards and 2 front yards for setback purposes. That is what applies to the subject property. Unlike alleyway lots where the yard facing the alleyway is considered a rear yard, the front setback standard is applicable to the west and east sides of the subject property, which face Sunset Way and Paso Grill Way, respectively. So the applicant is requesting a variance to allow for, sorry, the request is written there incorrectly, but in the table it is accurate. They are requesting to install a fence wall that extends to the property line along Sunset Way. You can see here a recent survey of the property. There is a home under construction. This is the foundation survey showing the conditions at that time. Since this foundation survey was filed, there was a request made to install a pool in the backyard of the property. You can see here the request. This was the markup that went out with the notice for this hearing. The area in green is the location of a fence wall that is proposed to be 4 feet in total height that fronts to the bottom of the screen, Paso Grill Way. The area in yellow without the red outline is the location of the fence wall at 6 feet in total height where it is permitted to be by code. That 10-foot area behind the dashed line at the top of the screen, that's the west side of the lot abutting Sunset Way, that is where a 6-foot tall fence wall is proposed that is within the required front setback for this lot. That is the portion of the fence wall that requires a variance. Were that fence wall 4 feet tall or were it to be stepped back to the dashed line, it would meet the code compliance standard. It is the fact that it is 6 feet tall west of that 10-foot setback that this variance is required.
Brandon, sorry to interrupt, but do you have a site plan that shows the pool?
I have a sketch of it coming up. Yep. You can see some existing surrounding conditions on this slide. This is a street view, but it shows the property without, or sorry, the adjacent Sunset Way without. There were a large number of vehicles when we went out, so this is a cleaner view of the street. Here's some photographs of the site itself. This is looking from the 2 sides of the 2 street frontages. I can see the view here from Paso Grill Way, looking toward the Sunset Way side of the structure from the Sunset Way. Another view out toward the street, looking at the under construction pool area at the back of the property. Another view toward the backyard. This is taken from the Sunset Way frontage. Staff finds the request is unlikely to cause significant adverse impacts related to aesthetic incompatibility or visibility relative to existing conditions, looking at both the proposal, which it's been several years for the property to the north, as well as the existing access conditions to the property to the south. We do not believe that there will be any visibility concerns based on the construction of this fence wall. Fence wall, particularly the wall portion, somewhat matches the design of the residence. It does have a solid portion, as shown in the plans attached, that matches the view of the building. There is a composite in between. It's a solid wood look fence portion, and we did ask that the applicant bring an example of this if they have one available. However, staff finds compliant landscaping could be effectively used for privacy rather than the fence wall approved by the subject variance. That would be on the Sunset Way where the variance request is being made. Additionally, the current layout of the site with the home nearing completion provides limited opportunity to design the site to mitigate the impact of the request. The request had been made earlier in the design process. It may have been better comprehensively planned with the layout of the home as is found on nearby lots and was shown in the photos earlier in this presentation. So you can see some of the past reviews that staff has undertaken with these requests, starting on the left side of the screen. That was a design review request that went forward. It did show a pool. It did show the pool at the 10-foot setback from Sunset Way. That was reviewed back in October of 2023. There was no reference to a fence wall at that time. Showing the middle plan, that was in March of 2024. That was when the request was approved for a building permit. At the time, the pool was not shown. Often they are added separately, so that's not of any concern to staff. They did show the frontage landscaping along Sunset Way that was required, and that will be checked at final inspection for the home. And then you can see the pool plan on the right-hand side of the screen. You have Sunset Way to the top, Passer Way to the bottom. It's a little hard to make out on the screen, but at the time when this was applied for, back in early July when we approved it, there was a 48-inch tall aluminum picket fence that was proposed along the property line. I believe later that month was when the application was made for the subject fence wall. So we have been working with the applicant and discussing this with the applicant since late July, but there were multiple revisions to the plan for both the site, and then there was the revision for the submittal rather for the pool that did not show the fence wall. So our request for the applicant testimony, we did share this with Mr. Pressman as a request for testimony earlier, I believe it was last week, whether an open design more compatible with the balconies and other features of the residence was considered instead of the wood look inset composite material that was shown in the plans, and if they have a rendering of the wall or the sample with the color proposed composite inset material, we would appreciate that being shared with the board as well. Staff recommended conditions, we have two. Unless an alternative design is approved by the Historic Preservation Board through design review, the fence wall shall be a complementary clad in masonry to the primary residence, and the fence screening panels shall be a composite or aluminum with color and design compatible with the primary residence. Item 2, any future driveway access provided to the subject property from Sunset Way shall be subject to the visibility requirements of Land Development Code Section 6.21 as amended, which may include required modification of the subject wall or a future variance. They do appear to have a gate for a walking path access to Sunset Way. It is not wide enough, from what I can tell, for a drive aisle, and they're not proposing that under the scope either, but we do want to reserve the right to review that in the future should it be necessary. As always, motion options, motion to approve the case with or without staff proposed variances or with other variances that are supported by the board, a motion to deny the case, or a motion to continue the case to a future date. And again, I'm sorry with that case number, that is 25145, not 25125. Happy to take any questions.
Real quick, Brandon, were you saying that your understanding was landscaping could be a potential alternative to the fence?
Correct. They would be allowed to have a fence wall of 4 feet in height within that yard, just as they have on the Passer Grill Way side. That in combination with landscaping, and they do show the landscaping plan that's proposed. We do allow for higher shrubs and so on. It's just the fence wall specifically. That had been cited multiple times in the application as a privacy issue as a basis for this request.
Is there not a law for, or whatever, is there supposed to be a fence of at least 6 feet around a pool, or am I mistaken?
There has to be a fence of at least 4 feet. It needs to be a pool compliant fence, and there needs to be a gate at least 4.5 feet tall, but it's not required to be 6 feet. This would be surrounding and acting as the pool fence, to my understanding, the pool barrier rather.
So it's legal to have just a 4-foot fence around
a 4-foot, as long as it's a pool compliant fence, yes.
And Brandon, do you have other pictures up and down that street, just in terms of precedent for what's going on in that area? As you mentioned, that's kind of a unique area with 2 front yards.
So this is showing, and I do want to point out that the image on the top is 4 years old at this point, but looking to the bottom of the screen, those are some adjacent properties that have some barrier of some kind in the frontage yard that faces Sunset Way. They do tend to be recessed. And Kristen, if you could just comment on these, I believe you.
Sure. So as far as the 2020 view, as you know, as a result of the hurricanes, it's hard to get a blue skies day of looking down Sunset Way without multiple trucks blocking it. So I just wanted to give you an overall perspective of that improved street. As far as when we did our site visits, we took a jaunt south, and the property on the left hand of the screen that is adjacent to the subject property, so they had a little knee wall high fence there. And then as we traveled further south, there's been some homes in the middle that was demolished, but they left the existing fence, so you can see it's set back. It may be higher than the 4 feet in height, but it's recessed approximately probably the 10 feet, and then they went up to the 6 feet in height. And then the one on the far right, it is recessed. That one, I believe, also is a corner, but they do have, it's hard to see, but they have a 4-foot high fence, probably meets that setback requirement from the avenue, which it's located, and then also Sunset Way, and then it bumps up to meet that requirement. So those are just examples in the area of other ones.
So all up and down there appear to be compliant?
For the most part, yes.
Okay. Thank you.
Any other questions for Brandon at this time? No. Thank you, Brandon. If the applicant would please come forward.
Thank you. Good afternoon, Madam Chair and board members. My name is Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg. I'm here happy to be working with Mr. and Mrs. Foster and their daughter Kendall regarding practical difficulty. That is, your staff has made some positive findings about. And really what this is about is really nothing more than what 99.8% of every other single-family residence in the city is seeking, which is just simple security and privacy and safety of their home in their backyard. That's what this is all about. So I do have a PowerPoint for you to walk you through. The issue is to increase the wall height within a front yard from 4 feet to 6 feet. Not a great amount of degree. We see these obviously at virtually every residence in the city of St. Pete, St. Petersburg, Pinellas County, and onward. I think you're familiar with the location south of Pinellas Bayway. Brandon, we appreciate the help of the staff, by the way, showed you the location. And this is a site that sits between Paso Grill and Sunset Way. Now, very importantly, this is a lot that's called a through lot. And as your staff indicates, there are only a handful of these in the entire city. So it's very unique, it's very singular. And that site has 2 front yards. Has a front yard that acts like a front yard, but its rear yard is determined to be a front yard setback, but still acts as a rear yard where a pool, lanai, and deck would go. So when you look at that situation and how it affects this property specifically, again, just a handful in the city as indicated by your staff, it creates a tremendous problem. It creates a tremendous practical difficulty. So when you look at a typical residential lot, front setback 10 feet, rear setback is 0. But a through lot is different. Front setback on the 10, front setback 10 feet, front setback 10 feet on the rear. You're allowed the 8-foot wall at a 0-foot setback, but only a 4-foot wall at a 10-foot setback. And looking again at a typical residential lot, you have an 8-foot wall at a 0-foot setback. What the Fosters are asking for is a 6-foot wall at 10-foot setback. So this is a photo of the rear as it's being developed and finished up at this point. You can see part of the pool structure there. And this is very important for you. The original submittal that was made did not have a lot of detail of the fence structure or wall structure that was proposed. So here's updated for you. As you can see, it's used as a wood material, which is very warm, and a masonry element, which is indicated in the staff report at some point would be preferable. Now, the wood feature would match a feature or two on the home. So there is a compatibility between that and the home. And this is just another view of it. It does have some slatting, so it's not a complete forceful wall, but it provides a decent amount of security. Safety is an important factor with a pool to be sure that that's safe, and privacy for the family. Like, again, I'm going to beat a dead horse, 99.8% of every single family home in City of St. Pete has that. Now, this is what was submitted with the application. And you can see there just wasn't a lot of ability to understand or get a concept of what's called for. But it is important to note that part of the structure is 6 feet, part is 4 feet. So it's not the whole length being 6 feet, part of it's being 4 feet. Let's look at the city staff report, because your staff made some very strong supportive statements, both summary and,
Can you explain what you were just sharing on the previous slide?
right now.
No, the previous.
The 4 versus 6.
Yeah, what you, is
This was the original submittal into the file. This was all the staff had to go with, which is just a black and white, but also showing part of the structure would be 6 feet and part of it would be 4 feet.
okay, so you're not saying this is coming in this area that we're talking about right now?
Yes, this is a schematic of what is proposed, and I showed you this photo,
Proposing a step down in the back.
as shown here, yes.
Okay, so this is all along the back side that is on Sunset Way?
That is correct. I'm sorry?
Sorry, I'm Matt Foster on the
You might make a
owner.
correction.
The 4-foot step down, that would be at the front yard where the actual driveway is. So the variance is just for the area around the pool, which would remain 6 feet. This shows the step down to 4 feet at the driveway for the true front yard where the driveway is.
Which is not where,
Passagirl Way.
The part on Pasco Way is going to be only 4 feet, though. Okay.
and that's not what we're concerned about anyway.
Okay, I'm going to ask, maybe you can put this on your overall layout of the site plan, because I still am thinking I'm hearing two different things, which is along the back side of or on the second front yard, the one on Sunset Way, where there is that this is me looking on Sunset Way towards your home. I will see a 6-foot fence and half of it, and 4-foot fence on the other half.
On
That's
Sunset,
the west side of your house,
on Sunset Way, it'll be the 6-foot fence.
all the way up and down, the entire.
Correct.
Okay, that's
The
why I was.
4-foot step down
Okay,
is at the front yard where the driveway is.
thank you.
So I apologize for confusion. I actually had some confusion, and I think we cleared that up for you, ma'am?
Yes.
Okay, thank you. So I apologize for the misdirection. So looking at the staff report on their summary, they note, and this, I think this is very important, staff, this is quoted from your staff report, staff finds the subject property or variance not substantially out of character aesthetically with the neighborhood, nor likely to cause visibility issues, and existing access conditions would not be significantly degraded. I think those are very strong, important statements from your staff. So let's look at the criteria, which is a 4-step criteria. The first criteria is just stating what the practical difficulty is, which in this case would be from 4 feet to 6 feet in terms of height of the wall structure. Criteria number 2 is whether an adverse change will be produced in the character of the neighborhood. And your staff finding, which I think is the strongest statement that you'll hear from the staff report, that will not have an adverse impact on the neighborhood. That's a very important finding for obvious reasons. And I think the staff states this very well, that desiring limited additional privacy in the backyard is not unusual or out of character. Fences and walls of 6 feet are common in the backyard of properties that lack 2 opposite frontages. Looking at criterion number 3, whether the difficulty can be obviated by some other method feasible for the applicant. Well, sure. I mean, there's a lot of different options. There's a lot of different materials, including screening, that could address this issue. So it's a question of determining in a development the structure that's going up, the compatibility of it, looking at security, privacy, and safety, and aesthetics. And I think my personal opinion is I think what has come forward is an aesthetic element. It does provide those aspects. But in regard to criteria 3, I mean, that really could be applied to any practical difficulty coming through in terms of some other solution or some other way to go. But I will tell you that the Fosters are open-minded, and they understand that there may be aesthetic concerns, and we're always happy to work with the city or with the board, but we think that this is a really good presentation of how to best address the situation. Criteria number 4 is whether, in view of the manner in which the difficulty arose, the interests of justice will be served by allowing the variance, and the staff finds that the visual impact of this variance is likely significantly lower than if a similar request were made along the property line of Pass-A-Grill. Staff finds the fence wall design to be somewhat complementary. So those are the specific criterion regarding practical difficulty, which I think your staff has responded to very strongly and in a very more than reasonable manner. I will say to you that Matt did provide me, if we could go to the overhead, just real quick to show you these, that there are some circumstances in the city where these structures do exist. This is one, and this is the other. Matt made a tour looking around for similar circumstances. But I would say in summary, Madam Chair, board members, that again, as your staff has indicated about this practical difficulty, that there are just a handful. And all the Fosters are looking to do is have a home like everyone else does that provides security, privacy, and safety in their backyard.
Is this
for
picture
themselves and for
right
their
here,
dogs.
is this on Sunset Way?
No, go ahead, Matt.
No.
So if you go back one, yes, this one is on the 2900 block of Sunset Way. So it's the next block over.
Is that's 6 feet?
Yes. And this one right here, that is the 30th block. So that is separating Pass-A-Grill Way and Sunset Way, and that is a end lot which has a 6-foot fence, and the code says you can't have a 6-foot fence on an end lot like that right there. And I brought that up during my conversations with Brandon Berry and the city attorney, and they actually agreed, and I gave them the permit number, and they said that they must have approved it by accident then, that it shouldn't be allowed.
Yeah, I do see a step down to 4 feet.
That's at the
As you
front
approach
yard,
the-
which I will have
Yeah.
at my property, yes.
Yeah.
Any questions for the applicant?
Yeah, do you have that image of where, and I think you showed it, but the pool, and how far is that set off of the,
How far back from Sunset Way?
yes.
Yeah.
If we could go back to the PowerPoint, please, thank you. Is that what you,
This one?
is that what you wanted to see?
I think,
That one does not show the pool. The staff has,
report has-
yes.
Oh, okay, all right,
Yeah.
maybe I'll ask Brandon to share. Okay, I don't have any questions for you right now.
Thank
Madam Chair and board members, thank you. We appreciate your time today. We are happy to answer any questions and be able to work with you in any manner that we can. Thank you.
Thank you.
Brandon, if I may, I had one last question for you. You mentioned something earlier about a walkthrough.
Yes, and I can show it on the same site plan. Let me get that pulled up.
So, while you're pulling that up, we're going to see a walkthrough, but also understand what the current setback is at the pool. And if the 6-foot fence was butted up against the pool, is that at a setback from the sight line that would be appropriate for 6 feet?
So it would, I believe the water's edge of the pool is set directly at 10 feet, which is the minimum. That is the minimum front yard standard, and it was proposed to be constructed. I pulled up the wrong request, but this is showing that walk gate at the back of the property. You can see that opening on the top of the screen along Sunset Way. I believe it's approximately 5 feet wide.
Okay.
And then looking at the pool plan on the right side of the screen there, that is I apologize, it's an 11-foot setback from the water's edge to the property line along Sunset Way.
And it requires a 10-foot to have a 6-foot wall.
Correct. The wall would have to be set back to 10 feet.
Okay, and then okay, so they can have a 6-foot wall. It would just be at 10 foot, not at 0, which is what's being requested, a 0-foot setback?
Can you go
With a
to
6-foot wall?
that, like the nice orange graph that you do, or that shows exactly what they're asking
Table.
for?
Sorry about that.
Yes.
Yes. So, yes, they are proposing effectively the fence wall being on the property line. There may be a footer. I don't know if it could be placed right at the 10-foot mark based on where the pool has been approved to be located, but the applicant may be able to speak to that.
Okay, thank you.
Looks like there's a a building maybe 2 houses down that's right on the property line too. I don't know if it's a garage. It's like a large white.
Yes, I believe the neighboring property or 2 properties down, as you mentioned, the building is right on the property line. I believe that's currently proposed for demolition, so we don't know if that's going to stay.
If I may,
on.
that is correct. We have a demo permit in for that. So once that is demolished, it will be required, just as Mr. Foster, to meet the setback requirements. So it's a pre-existing
You're
non-conforming.
talking about the one with the big white fence that you see on Pasagrove Way?
No, the one to the south, the more Mediterranean, it has the,
Oh, yeah, okay.
that one with the detached garage in the back.
I know it. Yeah.
So yes, correct. Once that it has been removed and it's a pre-existing non-conforming setback, anything that will be constructed will need to meet the setback requirements similar to the property in question.
Is that also a through lot?
That is also a through lot. Correct.
Any other questions for Brandon? Thank you, Brandon. Do we have any public comment?
Oh, can I ask the applicant a question about that? I would like for you to come back. I'm sorry, what was your name? Matt, yeah, thank you, Mr. Foster. Could you clarify, so it sounds like there is a solution for you to get the privacy with a 6-foot fence at a 10-foot setback. Given the location of your pool, there would be opportunity for you to do that. Is there a reason that that's not something that you're willing to put in that location?
I don't have the pool plan in front of me, Brandon, but what was the distance from the edge of the pool to my current setback?
He said 11.
11.
It's proposed at 11.
Give them like a 1 foot.
And if,
Versus a 0 foot, yeah, so.
and if I may, that is a proposed plan, so we have not gotten our final as-built survey as part of the new home.
Sure.
So again, these are guesstimates,
Okay.
what they're proposed. I just wanted to put that on the record as well.
Brandon, is it 10 feet from the water line or the end of the coping?
From your sight line setback is what we're talking about.
Requirement is, okay, so the coping is at 10 feet.
Okay.
And I'm fine, like, I'm here to be a good neighbor. I want to work with everyone. You know, I'm even fine with bringing the fence in a couple feet, and I would like to put a hedge on Sunset Way. So you really, as far as I know, there's no hedge height requirements. So technically I could go even higher, but I would like to put a hedge on Sunset Way as extra privacy. It's just, you know, having a 4-foot fence by a pool area with my wife and daughter is just a big privacy security thing for me. And there's other houses, you know, in that area that do have that 6-foot fence. So I'm here to work with the neighbors and do what we can to make this work.
Okay. Are we good for public comment? Sure.
Ready? Tina Douglas?
I'm Tina Douglas. I live at 2811 Pasagrove Way, and I'm having a bad allergic reaction right now, so my voice is hard to hear. Bob and I have owned the house across the street, 2811, for nearly 50 years, and have seen a lot of changes in Pasagrove. And not all of them are good, and we all want to be good neighbors, but when Peregrine Construction, which I believe is Matt's company, bought the property and started to build, he initially asked for a variance to build that house taller than was allowed, and that variance was requested so they could have an elevator access to the terrace on the top, and that was denied by the Board of Adjustment, which I appreciate. Now we come along and I hear from Brandon that there hadn't been any fence or wall or any kind of demonstration of how they were going to make privacy and safety that they're so concerned about in Pasagrove. I can't think of a safer or more private place to live than where they've chosen to build. I do understand that it's good to keep people's children and dogs and cats out of their backyard, but Sunset Way is a way that everyone in the neighborhood walks their dogs, rides their bikes. It's a thoroughfare because it's much safer than Pasagrove Way. And I believe that if they build the 4-foot fence and put the hedge in, as he's said he would like to do, that doesn't cause any problems to them as homeowners, and it softens the entire effect of this very large home that's built on this property. I will say that it was a vacant lot when they bought it. There had never been a house on that property. So he was starting from scratch with a design. And all of these things could have been taken into consideration when he first built the house. So I would ask that the committee please consider that, even though they've brought up that there are examples that are not within the planned 10-foot setback or required 10-foot setback, that most all of us do follow the rules. We all, that I know of, my neighbors all have followed the 6-foot fence and 4-foot where it's required. So because they've started from scratch, this is a brand new house, and I know they want it to be beautiful and be a very lovely, safe home for his family. I think it can be that way and still not have to have a variance for a taller fence that blocks out and makes it more unapproachable and not feeling like it's part of the neighborhood. Thank you all for volunteering to be on the committee.
Let me ask you a question. I'm trying to understand how the 10-foot fence would affect you adversely.
8-foot, not going to affect me. It's not going to affect me across the street, the other side, but I think for the general look of the neighborhood, most every other home along there has either a lower fence, a lower hedge, or a lower wall. Many of them have no wall at all. It's just the yard. So I know my
You don't have a pool.
answering his question. So it doesn't personally affect me, but it affects the whole look of the neighborhood, and that's what I'm concerned about. Thank you.
How many of those places are pass-through housing?
Excuse me?
How many of them are?
She said it's not information that
Well, I'm just.
It's okay. Thank you.
Member Small, if I could just have you talk into the mic as well so they can get you. Thank you.
Any additional public comment?
Jack Schlossberg.
I'm Jack Schlossberg. I live at 106 29th Avenue, fronting Sunset Way. We're directly across from the new construction. I'm here to oppose the variance requested for 2814 Pass-a-Grille Way. My wife and I and several of our neighbors on Sunset are against the changes. The hardship changes are entirely of the builder's own making. From pre-construction to now, they have fought to push the envelope beyond the city's rules. An opaque 6-foot wall on the curb of Sunset Way, directly across from us, is uncharacteristic of this remarkable neighborhood. The original permitted pool plan featured an open aluminum fence with foliage. A 6-foot wall at curbside will encroach on an already narrow side street. It routinely becomes congested and dangerous on weekends, holidays, during construction on Pass-a-Grille Way. Currently, this road is always in use by foot traffic, dog walkers, bikers, frequent speeders, and on many days it's reduced to a single lane by the lawn and work trucks. This is both a safety and aesthetic problem that we hope the board will protect us from now and in the future. Thank you for your time.
Bob Douglas.
Just at 2811 Pass-a-Grille Way, Bob Douglas. Just in supplement to what my wife said, I understand the concern, but this building has taken up the entire lot. The pool added on the back finished the job. I doubt if there's more than 2 or 3% of the lot that is of pervious in nature. It's just one thing after the other to cover the entire lot from street to street. And if it can be done with vegetation, I think that would be much more acceptable to everyone visually, conceptually. Thank you.
That's all I have.
We'll close the open discussion and have board.
I believe the applicant has to rebut.
Go ahead, sir.
Thank you, Madam Chair. Again, Madam Chair and board members, appreciate your time today in reviewing this issue and your patience. In regard to the last gentleman, there have been no variances for open space or ISR, so the lot is not overbuilt. There was one request for height, which was denied. So what is existing on the site does not over-encumber the lot, as far as I understand in that respect. I think I've heard from two of the residents that a landscaping element would help soften the site and would help make the street look better. And Matt has indicated to you, and we would ask you to consider a condition that the fence be put at a 2-foot setback and hedging, landscaping be put along the front. I think that addresses very well the comments from the neighbors. But I have to dwell back on this. This is a practical difficulty, and there are 4 criterion. I think your staff has well supported those. We believe your staff has well supported those. This is a unique and singular circumstance. I'll say again, excuse me, but I'll say again that all the Fosters and their daughter Kendall want is the same safety, security, and privacy that others have. In regard to Ms. Garcho's comment, with great respect, putting their fence at 10 feet right at the edge of the pool is just, it's cumbersome. I mean, you want to have use of your property to a certain extent, certainly. But I would say with great respect, putting a fence at 10 foot right at that pool gives you no room to walk around the pool, gives you no room to be able to use your backyard in some manner like others, every other property in the city, to relax, put down a chair, sit, enjoy the pool and the sun. So I'll just finalize by saying, again, we're suggesting condition, which we think is a good movement to provide response to the staff comment and the neighbors. And we appreciate your time today. Thank you.
All right, we'll now open for board discussion only. There's a lot of factors going on here, right? Like, I think
Such a unique situation, yes.
through lot is unique, just like when we see pie lots and the lot and but I'm also frustrated by the timing of this request, and that this is new construction, which I agree should be able to conform to code, with the exception of the fact that it is a unique lot, and that this has come somewhat at the 11th hour, where the house is so far along in the process of being built that there's not a lot of flexibility in terms of being able to move things around, and I appreciate the need for privacy with a pool and a family and safety. Like, that's a real concern, as well. So I think that the landscaping option solves a lot of, the challenges from a safety and security standpoint, because there is no
Correct.
limit on hedging, so you can have those go, to 6 feet.
Yeah, and I think, not to cut you off, but I think also I think, is it Gulfway that is right up and down the public beat? Is that the name of the street? Like, it's
No,
Yeah.
the one,
Sunset.
Sunset Way or Passive Way?
Passive Way.
the one that borders like where Paradise Grill is.
Paradise Grill would be Gulfway.
Gulfway.
Madam
So
Vice
it is
Chair.
Gulfway, thank you. Up and down Gulfway, I think we can see where a lot of people have pools in the backyard, and they're conforming because I can walk past and see their pools. So I do believe that there's a lot of precedent for, and that probably has a lot more risk for maybe concerns of safety and security, given all the public passing through. So I would agree that I think there are options with landscaping, and I think based on the location and the opportunity to have tackled this in a different way to get the 6-foot wall with a 10-foot setback could have been taken into account. I think 4 feet should be fine with landscaping. I don't see where the practical difficulty was met.
Agreed.
But Brandon, you showed back up, so I feel like there's something we need to hear.
I did just want to point out to the board, in Passive Grill specifically, it doesn't apply in other neighborhoods in the city. The city does limit hedge height, newly installed hedges to 4 feet. They're treated the same as fences and walls, so I just wanted to make that clear.
Well, that's good to know.
I think that's a reasonable compromise, the 4-foot setback, 6-foot fence. the hedge no taller than 4 feet.
No.
I'm sorry, what are you suggesting?
Well, you were talking about a 4-foot setback.
Oh, no, I didn't.
Oh,
I'm
I
sorry.
misunderstood you then.
We'd,
I had at one point thought that they could have a setback up abutting practically where their pool edge is. I think what they came in, as far as the last comment said, that was not of interest, so.
they've offered a 2-foot setback.
Right.
Is what, yeah, was proposed.
So there was,
What if we said a 4-foot setback is
well,
necessary?
I don't think that's what they requested, so to me, I think well, anyways, yes, you
I was
could
just
make a
trying to strike
motion.
a compromise.
I mean,
Makes a good point.
the fact that the hedges can't be 6 feet, it makes a big difference to me.
Right.
Because that was a way to somewhat compromise and offset that.
The walls could be 6 feet, and then you could put up to a 4-foot hedge in front of it. And, I mean, it's an attractive wall, but it's personal taste, right? Everyone views these things differently.
I would
But-
say the setback then needs to be pretty much right up against their pool. I don't see why 4 feet versus 10, that's a pretty substantial difference. So if the pool edge with coping is at 10, I mean, then I would be more apt to say, okay, we could give them a variance for a 9-foot setback, not 4. They had an option to build this house differently, absolutely.
Yeah.
And this sets precedent for a massive amount of redevelopment that's going on, and especially right in that little block. So I think, to me, that's just where my head's at right now.
I think you nailed it with that comment, Kathy, that
You gotta build.
we need to be, with new builds, we need to be careful that we're sending the right messages to what we will tolerate, from a city perspective.
That's a good point if the house two doors down is
It's
going to be
about to get demolished,
Yeah.
and,
That's true.
and so
What would the setback be if he had agreed to have 2 feet of landscaping in front of the fence?
I mean, I guess right now we could ask if there is any interest in a continuance on this where we can get an actual as-built survey and understand what, if you're open to, if you really want 6 feet, then we would want to understand what the actual.
Yeah, I do have a question. So is there a hedge height requirement or not? Because I have an email from Brandon Barry from months ago saying that there is not a hedge height requirement, so I could have a higher hedge, and I feel like that's no longer true, so I don't know what's right and wrong there now, because I have an email from Brandon that says I can go to any height I want with the hedge. I'm not trying to go crazy high.
Okay. I don't have,
Kristen, can you confirm?
So I don't know the answer, to be honest.
I am looking.
Okay.
Brandon had said earlier that there was none.
And I did, I've already moved the pool to go halfway underneath the porch to allow more room for this.
Is it unique to that zoning category?
Yes, it would be unique to the pastoral overlay.
I hope you understand where we're coming from.
Yeah, I'm trying to be a good neighbor. I'm trying to understand the hedge height, because I have an email from Brandon that says I can go to any height with my hedge. I'm not trying to go to any height, but I do have an email from Brandon that says that, so that'll help me understand everything better.
We're checking it.
Okay.
And I do believe
If I
Brandon,
could ask direction from the board, when you're asking for continuance, you're asking for an alternative plan?
Well, from the numbers that we have today are somewhat, guesstimates, and so we're trying to understand what are the true measurements for.
as-built setback for your current pool coping line, and first of all, if you want us to just look at this variance as is today, then we can certainly, we can look at it that way, which is 0, and you mentioned a 2-foot setback, but it was a 0-foot setback with a 6-foot fence. And that was the request. I think then you said you could take 2 feet setback. So I think when we could look at that, and we could motion that out and take a vote. Or what we're asking is if you would want to come back to our next meeting, do with an as-built survey of where the actual fence line would have to be based on the build out of your pool, and we could look at it
with that in mind, and you could come back with an update to your current request.
There would be consideration for an alternative than what we've talked about today, correct, is what I hear?
Correct.
Okay.
I think that could be an option if the board was open to
I
that.
think that's a good idea.
You are open to that.
Agree to that?
Yeah. Because it's not finished yet, and there's still a chance to change things if necessary.
So I'm allowed to have a hedge at the 0-foot property line?
We're researching the hedge height.
We weren't discussing.
Well, not hedge height, I'm just saying, I'm allowed to have a hedge at the 0-foot, like right on my property line, correct?
You are able
Okay.
to have that. We're just checking in.
So my question is, yeah, if I could have a hedge height that you won't even see the wall on the other side, like a 6-foot hedge height that'll even block the wall, if I move the wall in several feet.
So, and I apologize, I was looking and not listening, so I may have some questions. Are you saying you would like to maintain the 6-foot-high fence with relocating it or pushing it more with an increased setback from Sunset Way with landscaping in the front to be determined of height and to be determined of front yard setback from Sunset Way?
Yes.
Well, let me ask you that. So to confirm, I can have a 4-foot wall at the 0-foot property line, correct?
That is correct.
Okay. And I would always have wanted a hedge at the 0-foot property line because I think that does look better, and I love great landscaping, and I plan to put in a lot of landscaping. So regardless, I would have always moved my fence in several feet to allow for this hedge. But my question is the hedge height, because I was under the impression from Brandon's email that I could have as tall of a hedge height as I want. Again, I'm not trying to go super high, but that's just what the email states from him. So that kind of will answer my question. If I can have a 6-foot tall hedge and move the wall in a couple feet to where you won't even see the wall, that's what I'm asking for. And like I said, there are other homes in the overlay district that do have a 6-foot tall fence. So I'm not the first one around the pool area.
So if I may, with your pool permit application that came in and you had the 4-foot-high fence that met the maximum height requirement, and I'm trying to see, was that actually a 0-foot setback as well?
The 4-foot fence?
Correct.
I believe so. I mean, my pool contractor applied for the pool permit, and then after that was done, I submitted a plan revision for the fence back like in July or August, and this has kind of been ongoing since then.
And I'm just trying to see where you said you had the intent that you would have always had your intent was to have the setback from Sunset Way, but if the original pool permit application showed the 4-foot-high aluminum fence, which is to code and meets our height requirements, if it was not showing that setback. From what you proposed and what you were going to then install. Because I'm just saying to the board, as the 4-foot-high fence that was originally approved as part of this, and I'm trying to find it on this little screen, if it had a 0-foot setback, where the applicant is now saying he would have wanted to provide vegetation, he wouldn't have been able to do that.
Yeah, and then during the historical review process several years ago, I believe you guys had me add in the masonry wall on the front towards the driveway area, which is fine. So we're just trying to continue that around the whole property. So it kind of all ties in, but that was something that the historical board made us add back in 2023, I believe.
Yep, and that is a part of a requirement of Division 20. Yeah.
So I'm just trying to kind of make it go around the whole property instead of just the front, so it all ties in. I think it would look a little weird changing fence styles.
Have we been able to confirm the height of the hedges?
If we could maybe take a
recess?
Recess, because I have 8 million open, so.
Let's see, what time is it? We'll reconvene at 4:30?
Sounds perfect.
5 minutes.
Yes, sir. We're taking a 5-minute break.
Well, I just have I have 2 questions. One is the picture
We're not going to take any questions on the case at this moment. We'll reconvene in 5 minutes, okay?
We're just on intermission. Well, we'll be right back.
Bathroom break, basically.
It's okay.
Transportation. what the hedge height rules
Correct.
are specific to Pass Grove.
So according to the Land Development Code, and I appreciate, again, the board just giving me a moment to look at several things here. Under Land Development Code, Section 2020 B, or actually C, 1B, where, or actually B, let me try that again. 2020 C1A, an opaque hedge with a height not to exceed 3 feet when fully mature. So that is our land development code, which does 3 feet, which does
the max?
yes, Chair. I mean, Member Core. So there is a maximum height requirement, and I did ask Brandon to forward me the email that Mr. Foster was referencing. And again, because this is a special lot, it does relay that 6 feet is allowed in the side yard. Fences cannot exceed 4 feet in height in a street-facing rear yard or rear 15 feet. This is a front. And you are able to use hedges which do not have a height restriction. So I can see where there could be some misinterpretation of the land development code. And because of that, I do want to, and with the board attorney's vision and guidance, we did advertise for relief from Division 6.15 as well as Division or Section 20.20. So because that is under there, you could have the ability to allow for a higher landscape if you so desire.
As a variance, as an additional variance.
So I don't have any issues. What she's saying is basically that the noticing was a little bit broader, perhaps.
Correct.
So that the public would know that there could have been some additional deviation or change to it. I think that would be sufficient if we referenced the LDC.
Okay.
So
if you'd like to go ahead and amend it to include some additional consideration.
So we could potentially provide a variance to allow him to have a 6-foot hedge, but require the fence to remain at the 4 feet, for example. And that would still be giving him, like...
I think what you should put into the record is a little bit of discussion on, the rule is basically 3. We've heard 4, and now you've proposed possibly 6. So maybe just in the record, a little bit of discussion of that and how that might impact the criteria.
Yeah, but if I'm not mistaken, it sounds like the applicant came in today with a different set of criteria, and therefore the variance request was about a fence, not about landscaping heights. So I'm looking at the applicant to ask if you would like, with this, given this information, an opportunity to continue this and relook at what it is that you need based on landscaping and fence heights and setbacks.
If I can have a 6-foot hedge, I'm fine with a 4-foot wall. I was under the impression that there was no hedge height requirements due to the email from Brandon, so this is kind of news to me. But like I said, I'm trying to be a good neighbor and make everyone happy, so my biggest thing is security and privacy. I wouldn't be moving to Pass Grove if it wasn't safe, but all it takes is one time, for someone to walk by. So yeah, if I could have a 6-foot hedge at the property line on Sunset Way with a 4-foot wall, that would make me and my family happy.
Okay. Thank you.
That sounds like a resolution to me.
Still a 6-foot wall of intensity on, at a 0-foot setback. It's a wall of hedge.
Yeah. Okay.
Yeah.
It's still a wall.
But is it going to be right on Sunset Way?
It would.
No setback at all?
I mean, I can bring it in a foot or whatever. I'm just trying to make this work.
How wide would the hedge?
I mean, technically, it has to come in like a foot, because you can't plant I would use occlusia, and you can't plant it like on the curb, so you would technically have to like plant it like a foot in anyway.
That was my point.
And then the landscape maintenance person kind of,
You know, width for the hedge.
Yeah, so it's, you're gonna, I mean, but we can indicate like the requirements and what that would be, but if it
Right.
was, if it was set back with a hedge to start and then the wall behind it, that feels a lot softer. And gives, if we think about, again, this is a through lot, and so most backyards, you are able to have that 6-foot privacy.
So we're changing the conversation from fence height to hedge height.
Basically.
well, I came into this
Well-
not realizing there was a hedge height because Brandon told me there wasn't, so this is all news to me. I'm just trying to make this work.
I feel like
Yeah.
this maybe needs a continuance because we need to reset with you and on what it is that your real variance request is. That's what I would probably motion to do if you are amenable to that.
I'm trying to get resolution today just because this has been ongoing since like June or July. There's been a lot of back and forth, and then it's taken a long time to get to this road, and it is holding up exterior construction because when you do block and stucco, there's going to be like dust, unfortunately. We're not putting on exterior finishes until this wall is in, so it is holding up construction. So yes, I came in today with the 6-foot fence, but I am open to, just doing a hedge instead. I'm just trying to make this work for everyone, and I'm just trying to get resolution.
Pool is fully constructed, correct?
Yes.
You have an as-built then survey of where the pool line is today?
It would match the pool plan. The as-built survey that we did was done at slab pour, which is before the pool was in.
Right.
The final survey would show the pool, but the pool that's constructed as of today matches the pool plan that Brandon has right here.
So you're confident the pool line hits the 11-foot setback, and with coping, it would be no more than an additional 10, then it's really at the
Yes.
10-foot setback line. So you're confident of that?
Yes.
Okay, then we can work with
Okay.
that. And what you're asking now is that you're requesting the variance to be focused on the landscaping, not a 6-foot fence.
Like I said, I didn't know there was a landscaping hedge issue because I was told otherwise, but if there is, then yes, I would just like to request a 6-foot tall hedge to soften things up.
So if I could just jump in, also, my concern is really what the record includes. Basically, in order to grant the variance, there should be competent and substantial evidence regarding the various criteria. I'm not certain how much information is in there already regarding the hedge. So I'll defer to your attorney as well if you feel comfortable going forward, or the alternative would be to do a continuance, but a continuance that's very focused on what additional information the board might want. But I did hear you say that you have concerns about delay in construction. So this one's a tough one.
Well, first of all, the record, not an attorney, not a lawyer,
Oh, I'm
zoning
sorry.
consultant. Well, I just want to make sure I clear the record. I think the staff report does refer to particularly criteria number 3, obviate with other materials or other materials or items. And I think there's a reference to landscaping and screening. Typically in city county codes, screening includes walls, fences, hedges, landscaping. They're all virtually put into the same category. So with the greatest respect, I would say that the discussion that you've had regarding screening and buffering includes landscaping and includes walls or fences and is referred to in the staff report.
Competent, substantial
Yes.
evidence in the record.
Yes, ma'am.
Okay, very
Thank you.
good.
Thank you.
I guess independent of the material, I would still stand with our previous conversation about the location and the setback. When I say location, I mean setback is still, I think, of something that we would want to require it to maintain if that's going to be at 6 feet, then I think the minimum setback is currently should be at 10. And if we gave any kind of variance that given where the pool is, maybe we would give a variance of 9. But otherwise, I would say we're having the same conversation. It's fencing or it's landscaping. It's still a matter of setting a precedent for new builds in this area, which there's certainly going to be a number of.
Yeah.
So that's where I'm at. Anyone
Well, I believe
else before we make a motion?
his construction concerns are valid.
Me too.
Yep.
He
we
came
should-
in looking for a fence, and we're making an adjustment, the Board of Adjustments, to take the fence back down to where it's supposed to be, and with that, he can put his hedge a little higher, and that softens the blow for the people walking down the alleyways, and
Yeah.
I think it's a win-win for everybody, if everyone's acceptable to that.
At
It's a matter
a,
of where it's being placed, the setback.
yeah,
Yes.
at a 0 lot line, or a 0 setback, or with that hedge being
No, it's-
pushed in a little
It's gonna
bit?
need as he said, a foot anyway. You can't plant it right on the
Well,
curb.
that's still on by the time it grows out, it's basically a 0 setback.
Well,
yeah.
maybe,
Do you have thoughts on location from a hedge perspective, if that's something that you think you
I
support?
appreciate all the points. I think it's a tough call because you are setting a precedent. The hedge is going to grow. It's going to get wider. It's possible, especially a tall one, to keep it trimmed in. So you have to allow for growth. I'm just struggling with how far, if you want to get it close to 0, how far back do you go? I don't have enough information to really say what that would be. Do you give the hedge 2 feet? Put 4-foot fence behind it? I don't know.
Valid points.
Okay, well, I'll make a motion to deny case 24145 for the setback variance for 6-foot covering at a setback of 0 foot.
And the denial is based on the criteria that has not been satisfied?
Correct.
Specifically,
I do not see a practical difficulty variance. I believe
Okay.
that there's satisfactory solutions with the current pool fence that was outlined in the permitting process to address the needs of
so
safety.
I believe it's criteria 3.
Criteria 3.
Yeah, whether the difficulty can be alleviated by some method feasible for the applicant to pursue other than the variance.
Criteria 3. Yes. Thank you.
Do we have a motion? Do we have a second?
Please explain again what the motion is. 'Cause
To deny the variance
just say
request.
deny it, and then he's back at square one again.
That's the,
She's
And
denying
you can
it.
have a 4-foot fence.
you can have a 4-foot fence at 0,
Or a 6-foot fence at a 10-foot setback. Yes.
Well, that's not satisfying.
Okay, if there's no second, then my motion dies.
yeah. Do you have an alternative option you want to discuss?
Well, I mean, I think it seemed reasonable to say, you can put a hedge in, we can decide how many feet back from the road, I understand, because it is going to grow. And then to have the 4-foot fence, which allows privacy and keeps that fence low. That makes more sense to me than just denying it outright, and then he came here for nothing.
Well, that happens. We have specific zoning and requirements for the way that things are developed. There was a presented package with permit approval, with this design that perfectly hits all of the marks.
And it's a new
And now
construction.
and there's several other that are going to be happening in the same vicinity. So you are correct.
But we probably want to be as flexible as we can be for all these other cases too, because every property is unique, particularly along that way.
This is to me, it's a very clear-cut design of a piece of property. It's not on a curb, it's not on a corner, it's just like the units on Gulfway where we look in the backs of their homes and their pools and they maintain their wall heights and they maintain their shrub heights. And this is even more private.
So
That's where I feel like the practical difficulty is difficult for me to.
I hate to interrupt, but was there actually a second to the motion?
No, motion died.
Okay. So now we're looking at an alternative motion.
Unless, unless there's a second to mine, correct.
Well,
I think they're saying that it's died for lack of a second.
So
I
then,
think it's great that, people putting in new construction and beautiful homes and I think it's gonna happen on all these streets, that people are gonna wanna come in and change some things as far as zero lot line. And they're in a tough spot, especially that street.
yeah.
And we'll probably have to work with a lot of people on this. I hate to discourage, new construction and building nice homes. I think we don't have to go to zero, but maybe we can, compromise somewhere in the middle. Back to the discussion of the 4-foot fence. And if they want to put a hedge in, they can. That's not a requirement, just the 4-foot fence. And if they want to put a hedge in front of it that goes 6 feet, that's up to them.
But maybe saying the setback is 5 feet instead of 10 feet, and then they can
Exactly.
do what they want with that 5 feet.
Exactly.
That's a good compromise.
That's a great compromise.
If they want to put a hedge and then the fence, then that's.
It's up to
that,
them.
But, yeah.
Does that make sense to you?
Well, I would rather not bring the applicant back up at this time. How do you feel about that, Kathy? Are you firm on?
Yeah.
Okay. Member Small?
I like your proposal. I think that, and I don't know if we need to ask him, but that's what we can make a motion for and approve. And if you can live with that, that's great.
So was the question,
We've not brought you back up. Sorry, sir.
So how many feet on the setback are we going for as 4-foot fence?
We were just splitting it to
No,
some-
the 4-foot fence is not a problem. He can do the
Right.
4-foot fence all day long.
We're okay with the
There's no-
setback that's been proposed, with the 4-foot fence?
No, it's
versus-
about landscaping now is what you all are talking about.
No, we're talking about a 4-foot fence, the 5-foot setback, landscaping his discretion. If he wants the privacy, he puts it up. If not, he wants to leave it open, that's up to him.
Landscaping has a limitation, though, what we just heard in Land Development Code 2021 C1A. It is
It's 3 feet.
at this, in this area, it can be 3 feet maximum on the front yard setback. On the front yard setback. Otherwise, it sounds like it's adhering to the same setback rules as we were discussing about the fence.
Point of order, Madam Chair, which is always in order. I believe your attorney told you that you can approve a variance for higher landscaping.
Correct,
If
we're
I'm correct.
having a conversation.
Based on the noticing, that the noticing has been satisfied, that component, my comment was, was there adequate evidence and has there
Yes.
been adequate testimony? You believe that there has, it is a decision for the Board of Adjustment to make.
My point of order was that your board, which I heard a comment, which I thought I heard, could not approve above 3 feet. You've instructed them that they can't approve above 3 feet for a hedge.
If they believe there's adequate evidence in
Yes.
the record to
Yes.
support an approval of that, because the
ma'am.
noticing has been proper.
Yes, ma'am, just a point of order, thank you.
I think that's the confusing point, because we heard two conflicting descriptions of it can be 3 feet or it could be higher.
We're just replacing, I think, the fence conversation with a landscaping conversation now. It's all still about height and setback, of whether it's a landscape item or a fenced item.
So it sounds like the two potential options on board are denial, new construction could have been done differently, have the 4-foot fence as the original pool permit was presented at the 0 lot line, or potentially offer a 5-foot setback with the opportunity to have a variance for a 6-foot hedge should he like.
Or not.
Or not. And then if he doesn't want to do, then he could just go back and do the 4-foot fence at the 0 lot line too. But it would give him the option to put in to have a 6-foot privacy barrier if he would like to.
Madam Chair, if I may, if we are going with another option and possibly the landscape height, I would like to recommend that I would like to see a plan come in reflecting that for the board to approve and everybody have a clear understanding of what the request is and the approval. The only caveat to that is it would be a possible continuance in order to get that to you to the next hearing. So if there is a time constraint with the applicant, I was just putting that out there as another option, but if there is a time constraint, I would like for the board to see it as well as staff to make sure whatever you approve is what is installed and maintained, especially I would suggest a condition if you do an additional height, that that's maintained in perpetuity, which makes staff have to check on that.
Yeah.
That makes sense.
I think I'm coming around to this is just reminding ourselves as a board of how much new construction we have going on in an area that we want to be very protective of from a pastoral perspective, and that we have to set precedents. And if you want to remake your motion, Kathy, I'm supportive of that.
Okay. Or you can make your motion. Which,
Yeah,
do you want to make a new motion to what you're proposing?
I would like to motion that we allow a 4-foot fence at a 5-foot setback, and that a separate variance would be issued for landscaping so that Kristen and her group could review and approve what that might be if they choose to have that hedge put in.
Board members, if you are requesting additional height with the, I'd like to know what the maximum height could be on that, as well as setback.
I'm proposing right now 4-foot fence, 5-foot setback, and then they have to come back.
They don't need a variance for that, though.
Yeah, they can
Correct.
do a 4-foot fence at 0.
They can do a 4-foot fence all day long. They don't need anything from us on that. So it's really all about
That's true, that's
the
true.
hedge location and height.
It's really the hedge, yeah, you're right, you're right.
So if you want to make a motion on that, you can go ahead.
But I'm not sure how to word it, if you want to know what the hedge is before that's approved.
I think you just have to think about the long-term impact, as Kristen was just saying, of now, like, we're basically putting in a unique, like, situation for one property that the city would have to monitor in perpetuity to make sure that the height of that hedge stays.
That's a good point.
Yeah.
And then that anybody could start now not asking for,
I
landscaping
don't see
specific.
there's any way we can settle this without a continuance. I mean, as you said, they can build a 4-foot fence anyway. But now we're getting in all this about regulating the height of the fence, and do they have to come back and inspect it every now and then, and that?
Correct. 'Cause if neighbors start complaining about the height of their hedges, he could come and say, well, the board said I could put it up to 6 feet and take his tape measure out. So we're not here to,
The other factors, to Member Gaucho's point, you could basically put a 6-foot fence at the, pool line. It's not ideal because you lose your backyard, but there is a way to do it if that is more important from a security, and privacy perspective.
agreed.
Or you put your 4-foot fence at the 0 lot line, and then you put a hedge behind it with approval if you want to hire at another time. I mean,
Yeah. All right, I'll make a motion to deny case number 25145 based on the lack of evidence heard today to indicate a practical difficulty variance.
Criteria 3, is that?
Criteria 3.
Yes.
I'll second.
Roll call, please.
Member Small,
Yes.
Member Schmidt,
yes.
Member Core,
Yes.
Vice Chair Garshaw,
Yes.
Chair Chase.
Yes.
Motion carries.
Moving on to our final case for almost this evening.
I couldn't hear the motion.
The motion passed as a denial.
Is it possible to ask a question?
Not at this time on this case. We need to move on to the next case. Case number 25141, 1982 West Vina Del Mar Boulevard.
Third and final case for today, unnecessary and undue hardship variance, case number 25141 for 1982 West Vina Del Mar Boulevard. Scott Edward and Kathleen D. Sullivan request a variance to install 2 tie poles with a 10.5-foot northeastern riparian line setback, where 17.8 feet is required. with the outer pole installed at 40.5 feet from the seawall, where 35.6 feet is the maximum distance permitted. This request is made pursuant to Land Development Code Section 6.23 D 3 and 4. Here's an aerial of the property. As a zoning of RU1 residential zoning, it is a single-family detached zoning district. The applicant is requesting two variances, both to the residential dock section of the code, that's 6.23 D 3 and 4, those pertain to length and riparian side setback for a dock. The maximum dock length is 50% of the zoning lot at the waterfront, that is 35.6 feet for the property. There is an existing dock that is at 40.5 feet for the property. They are proposing to match that distance from the seawall at 40.5 feet. That is for the outer tie pole of the wet slip. That is a new footprint. It does require a variance. There's also a side riparian setback requirement made pursuant to item 4. The requirement is for 25% of the zoning lot at the waterfront, that is 17.8 feet. Existing is 27.2 feet. Proposed on the northeastern side is 10.5 feet. Southwest is 18.7 feet. That is existing. There is no change. It is only the northeastern proposed setback that is required. It should be noted that the requirements of these sections, or this section, these items, may be varied administratively, provided that a signed statement of no objection from the abutting property owners is provided with the building permit application. In this case, the abutting property owners to the left, southwest, signed a statement of no objection. That the right, northeast, is not signed a statement of no objection. That does require variance approval to be sought, and that is the subject case. Here's a survey showing existing conditions of the property. Here is the request showing the proposed wet slip, the two tie poles, the bolded black tie poles at a 10-foot, 6-inch setback from the extended riparian line are the poles that require the subject variance. That is for both the setback as well as the length of the outer tie pole. The inner tie pole is compliant with the distance from the seawall standard. Here's some photographs of the site showing the sign posting. Showing the front of the residence, it is currently proposed for an improvement in elevation. This is showing a lookout from the seawall toward the marina across the way. Another looking to the northeast, and another looking toward the side dock to which the tie poles are proposed. There is a sailboat proposed and that tied up on the northeastern side. That is proposed for the wet slip. This is looking from the street end across the way adjacent to the marina toward the property and the abutting property to the northeast. Staff finds the request is not out of character with other similar dock conditions in the vicinity that were approved through administrative waiver, meeting criteria 8 of the requirements for an unnecessary and undue hardship variance. It would resolve the wake issues advanced by the applicant as the basis for this request. This property with its neighbors face potential commercial wake issues that are not experienced in significant proportion among properties in the same zoning district, fulfilling criteria 1 of the unnecessary and undue hardship variance requirements. However, we do ask that the applicant provide testimony as to how this request stems from a condition from the land or structure rather than purchase of a new vessel. That is condition 2 of the criteria, and whether the request is the minimum necessary or whether the slip could be relocated or reduced in width to provide a lesser impact on the abutting neighbor. That is condition 7 of the unnecessary and undue hardship criteria. So we do ask for applicant testimony that the applicant or their agent, who I understand is present, should provide testimony on the following: whether conditions have changed during their ownership of the property, such as relocation of wake zone signs, whether there has been a noticed increase in commercial activity affecting wake at their property, whether the tie poles for the slip could be moved in any distance to reduce impact on the neighbor, moving them further from the extended riparian line even if they don't meet the necessary setback, and whether the dock could be otherwise modified, such as exploring replacing the slip at the outer side of the head. That would also require variance and waiver pursuant to the Land Development Code, or modifying the head width to relocate the poles further from the neighbor's riparian line. Should this request be approved, staff recommends 2 conditions. Authorization is granted for wet slip as depicted on the dock plan submitted for the subject request only. That would include any modifications made by the applicant as submitted or by the board. Future installation of a boat lift must meet all required setbacks and length limitations, must receive approval from affected neighbors. It requires a subsequent variance subject to the standards in place at the time of application. Item 2, a final as-built survey shall be required, which shall provide the length of the tie poles from the seawall and riparian line to ensure the slip has been installed in accordance with the dimensions shown in the request. Your standard motion options: motions to approve with or without recommended staff conditions, motion to deny the case, motion to continue pending submittal of additional information. Happy to answer questions.
Thank you, Brendan.
Can you go back to your page on the criteria? Or condition, yeah, okay. So your administrative waiver, could you, I'm not sure I know what that one is.
So docks are one of the few structures in the Land Development Code that allow for neighbors to effectively provide some degree of waiver. That is the administrative process I'm discussing.
Okay. And this didn't go through because one of the neighbors?
Correct.
That's correct.
Yes.
So criteria 8, and did we actually get the neighbor not approving it or just no comment?
When this was submitted, the neighbor had requested a signature from that neighbor, and they had not received a response, from what I understand. But I have since heard from the neighbor that's affected, and their letters were in the packet.
Yep. Okay. And so that aside, then what you're saying is that criteria 1, can you clarify what that one is?
That is, there is a hardship of the land structure building that isn't experienced among other properties in the same zoning district. Generally speaking, properties in the RU1 district, which are obviously numerous throughout the community, they don't tend to face the issue of a commercial properties across the waterfront from them. So to the extent that there is wake issues at the property, that would be something that, although they share that issue with their neighbors, it's not experienced in a significant frequency among other properties in the same zoning.
And there's nothing new that's changed, correct, for these properties?
That's part of what I've asked the applicant for testimony on, if there's been a change in the wake zone sign, if they've noticed an increase in commercial activity at the properties across the way. If there is some testimony they can support in that regard.
Okay. Thank you.
Any other questions for Brandon?
No.
Thank you.
Thank you, Brandon. If the applicant or agent would like to please review the case. And thank you for your patience with us.
Good afternoon. Thank you so much. Okay, so thank you so much for your time and your patience. I really want to thank Brandon for his detailed report and Kristen for all their support and the professionalism of actually going through this, and all of your time and your dedication to the service of our community, so I appreciate it. Thank you. My name is Scott Sullivan, and my wife over here is Katie Sullivan, and those are our children. Our home is currently 1982. West Vina Del Mar. You can't hear me?
That's better, thank you.
That's better? Okay. Our home is at 1982 West Vina Del Mar Boulevard, as Brandon showed us. We've lived in St. Pete Beach since 2017. We've had this property since 2019. And we're finally back in it after we were going through this extensive renovation and lifting it, though it's not done. We also have today my marine contractor is Brian Berg from Edge Marine, and he'll be happy to answer any kind of technical questions that we have today. What we're asking for is a limited variance to install 2 tie poles on the right side of our existing dock to safely moor a 30-foot sailboat. That's really we're not, very, very clear. We're not changing the dock. The dock is there. The sailboat's currently tied to the dock. From a safety perspective, it's really suggested that we have 2 more tie poles in there. And the real issue is that we're probably in the most, it's a commercial waterway. There are we are inside the idle zone, but there's a significant amount of boats that still come through there and create a lot of wake. And there's a lot of traffic, and that's what is causing the issue. It's not, the sailboat's not causing the issue, it's the environment that we're in right now. We are not asking to extend our dock, we're not asking for a boat lift, so those conditions that Brandon and staff has recommended, we are fully supportive of. Just looking for the 2 pilings to safely secure the boat. We did go through the processes, as Brandon mentioned, for looking for a letter of no objection. We did get it from our neighbor to the left. We had a conversation with our neighbors to the right. I believe he's here today. He verbally said it was okay to provide the paperwork, and then they wouldn't engage. So now I see that they've written some comments. We've had some other conversations with our neighbors, including 2 doors down, who recommended Edge Marine, and he's used them to build a dock. He's also done other work in St. Pete Beach, so he comes highly recommended. The other significant thing is we've gone through all the proposals, and we've gone through different types of alternatives, and in the opinion of, and we can ask Brian, but in that opinion, this is the minimum variance necessary to safely moor the sailboat. And appreciate your time and happy to answer any and all questions.
So you want to put these 2 tie poles in because you're getting a larger boat? Is that the reason, or is it the current boat you have now?
Current boat that's there right now.
Well, then why do you need the 2 more tie poles? I don't really understand that.
Well, if we could see, can we show the picture again? Or I also have some pictures. So, yes, on the left, we have a boat with our lift, and on the right, the sailboat has been there, and it's currently moored. However, it does get a significant amount of wake. And this is where it's been recommended that we put the 2 tie poles.
Because there's a lot of wake because of the traffic right there by the marina and everything?
Correct. That the current construction is not really sufficient.
How does that mitigate the wake?
It doesn't, but when we have problems and we've had...
Can I help my husband? Hi, I'm Katie Sullivan. So my husband doesn't know a lot about sailboats. So it would need spring lines to cross to make it more secure, because without the spring lines, we've had it, and it keeps banging and banging and banging. And then when the weather goes bad, it can go the other side. So we have to constantly be replacing lines, because we don't want to hit it into our neighbor's dock either. So the most secure way to do it from Edge Construction is to put these spring lines in, to put the posts in, and then run the lines crisscross. So then the sailboat is absolutely stable, because it has this hull that goes back and forth, and you're not going to put it on a lift. So it keeps it the most secure, so it doesn't run into the neighbor's dock, and no matter who blows through, going to sea critters or the wharf, we're a-okay. It's safe.
It would be a huge wake to take you over to bang into the neighbor's dock anyway. I can't imagine that possibly.
No, it wouldn't, but the lines could break is the problem.
It just adds extra security.
We can ask that.
Yeah. Can you clarify, is this sailboat been moored here for how long?
A couple of years.
2 years.
Okay. And did you explore, are there some other options, given the space that you have in the back of your home? Maybe it's not aligned with your existing dock, but were there other... I heard what you said about the fact that the location of these...
We could do it in the front,
Uh-huh.
but
Can't,
then I guess we can't.
We actually looked at that. So we did explore other options, and I've been through all of them with our contractor. And... All right, thank you.
My name's Brian Burge, 4790 95th Street North in St. Petersburg. And Sullivans here, they actually represented themselves, which was nice, helps me. And so, anyways, we provided the knowledge first of what we should do, and then some documentation, so then he could move forward to apply for this variance. And basically, what we propose to limit and do something the most cost-effective way, as far as, you know, less alterations, keep the cost down, is to propose this wet slip on the north side of this dock. We also decided, and some of you may know, a lot of cases you can see wet slips that have multiple tie poles and sometimes 2, 3 clusters in one position, to keep the you know, aesthetics down or less evasive and make neighbors happy. There's just single tie poles here. In my honest opinion, in that area, you could probably easily do double pilings in those corners. But again, we decided to choose a single one in each corner, 2 total. From a functional standpoint and safety standpoint, the boat, as you see it in this photo, should stay oriented in that position. That's the way it should sit for whether it's being hit by wakes or wind. That's why the boat's designed and it's shaped that way. If you were to turn it any other direction other than its face right now, it's just it could be detrimental. Anytime you turn a boat sideways, it turns into a sail. That's a sailboat. But the boat itself, even if it's a center console on a boat lift, you know, the boat catches wind. So putting the boat any type of parallel position to the seawall, really at any property, but more so this property where it's located, would not be a good idea.
No, you can't do that, I understand that. Where would the 2 poles be put? You're talking about 2 more tie poles.
Yep, so if you want to get an idea of where they would be, that boat is about 10 feet wide roughly, and so if you can picture about 5 feet to the north of where the boat is sitting now, there'd be a piling in line with the end of the dock at the 40.5 feet off the seawall, and then the other one would be about almost even with the back of the dock, kind of where, almost in line with those 2 taller poles, if you can see those sticking up, basically straight across from them.
So you're going to have the tie poles on either side and put the boat in between.
Yeah, the goal is to always keep, if you have any wet slip, no matter what the boat is, whether it's a sailboat, a power boat, or whatever, you want the boat in the center of the slip. The only way to you know, get a boat in the center of a slip and off the side of that dock would be to have pilings on the outside of it to keep
So
it
you
off.
said the beam was 10 feet.
Yeah, I think it's right around, oh, sorry, it's 11.
What is the actual spacing then between the poles?
The spacing is 15 feet in between the piling.
Okay, and can it be less than that? Does it have to be that wide?
It's not really suitable. So if the boat's almost 11 feet, so the slip itself would be about 4 feet wider than the boat, and the bare minimum you'd want is about 2 feet on each side of the boat if it was centered.
Does this in any way adversely affect the property to the, looks like it's the north?
To the north? You know, I do this a lot. We typically would never design something that would adversely affect any neighbors. And it's my opinion that it will have 0 effect. To give you an idea, once those pilings are installed, and you can see from this photograph, it's a good example, from the new pilings, it would be about 30 or more feet, 30 feet or more to the neighbor's closest structure, which would be that boat lift in the photo.
That's the only boat they have, is the boat lift?
Next door?
Yeah.
No, they have a much larger, they have 2 slips next door, 2 boat lifts, a floating dock you can see in the photo. So they have 2 mooring slips next door, and that's what we're requesting to put it
But
this
they're
way.
not docking a boat on the side toward your house, correct?
No. The closest spot they moor a boat next door would be on that lift you can
On the
see in that
lift.
picture.
And we'll have the opportunity to hear from neighbors, I believe, as well.
If you have any other questions, I
So you
think.
did explore, though, other designs?
Sorry?
You did explore other designs that would meet?
Really,
the
there's only
criteria?
one other design, which would be turn the boat parallel and
Okay.
put it out to sea further, which, like Brandon said, that's also a double variance from a length perspective. And that's the, at our property, you can see the boat he already has on the boat lift. That slip still needs to be usable for that boat to get on and off that boat lift. So really, the north right side of that dock is the only position to put or add a slip.
Okay, so the north right side.
Yep.
I see it does have a area that's protruding out from the actual 4-foot
Yes.
walk out.
The dock, yep.
So I guess the alternative is to lose that walkout space so that you could actually bring it in tighter to the 4-foot dock,
Correct.
correct?
Yep.
Okay, so that is a potential solution?
Yeah, that would be a potential more costly and then loss of square footage of the dock
On
solution.
the end of that dock?
Correct.
Okay,
Mm-hmm.
but it then doesn't protrude into the
Setback?
wreck?
No, correct.
Okay.
And just to make it clear, so everyone's on the same page, in this particular case, any objections that have came through on every property from someone that placed an objection, they're all double variant situations that they have behind their home. They've all received signatures from neighbors to build structures behind their houses. And so we're asking for nothing other than other residents have done.
Any additional questions for the applicant at this time?
Yeah, I guess if that's specific, if you have very specifics, you're saying about the fact that everyone else has got the 10,
Yes, and anyone
10
that's.
and a half foot setbacks from their neighbors'
Yeah,
areas?
the number might not be correct because the lot size could be different, but each neighbor has had a signature to build their dock or their slip.
Right, like this one had that same variance to be at the 40 and a half feet, right? That's
Yes.
also requiring, okay.
Correct.
Okay.
Another example, real quick, is the overall footprint of the structure, which we would call the envelope, which would be the total width from maximum side from structure to structure. In this case would be the boat lift that's on the left side of the dock over to the proposed tie poles that we are proposing. The overall width is within 2 feet of most of the other structures that are in that body of water too. So it's pretty consistent with neighboring properties' widths. And also, our property, subject property, has a much shorter distance out to sea than neighboring properties as well. So it has a much smaller footprint than almost every dock in that body of water.
Do you have an aerial view at all showing the neighbor and in your house?
This one's. Oh, that one shows. Yeah, I'll show them this one first. That's a little more. Do you mind?
Get the overhead?
Overhead. So, this, you can see our subject property, the sailboat, which is in the bottom of the frame. And then you can see the size of the structure to the north, which is the neighbor. And you can see the size difference in the length of how much further it's out into the canal there.
Are you number 9 here?
No, number 9 is the neighboring property.
They're kind of falling off.
They're at the very edge.
There we go. Okay.
This one's a little more zoomed out, but it does show all the properties. So you can see 8 and 9, the size of their footprint or their envelope. Then moving down to the south would be our subject property where you see the sailboat. And then if you move further south and wrap around the corner, you can see the length and the widths of those structures. So like I said, we're not asking for anything even nearly as large or as big as some of the neighboring properties.
Thank you. Any other?
You said you've had this mowed for 2 years?
About that, yes.
And then the neighbors complained about it then? Was that a
No
problem?
one has said a word.
So it's not a visual issue?
The first time I saw anything was a comment on this report.
Has there been condition changes that make the current situation not something you can continue to sustain?
I wouldn't say I have no basis to say there's been a change in any of the conditions. I think they're similar.
Yeah, okay. So for the last 2 years, it's been okay?
No, it hasn't.
I wouldn't say it's okay.
I'm sorry, no, it hasn't.
Well, I was going to say too,
Place the lines, like through, when there's a storm, so it's my daughter, so we're up all night long, like constantly replacing the lines because it will take out our neighbor's dock. Like, and it'll either go to the seawall or go into their dock or
And the
something.
date of the neighbor's
So, and the
signature.
lines are
You have the one
constantly
they signed.
getting cut and like being, it's just a lot of
It's just more like
No.
permanently a boat needs to have, 4 points to tie up to. Like in the marina, that's just normal.
Mike? Oh, you're going to need to speak at the mic and you'll have to give us
Yeah,
your
have you
name.
been sworn in?
Okay, then
No.
that's okay.
oh, and so to answer your question about time, the first neighbor, so the left neighbor that has signed the variance, signed it in October of 2024. So it has not been okay for 2 years. We've been trying to come to a solution to fix the problem, and so that's why we're here. So it's just been ongoing for quite some time.
Thank you.
Thank you.
And what was the complaint then?
No, there was no complaint. It was just that when we started this process and we were able to obtain one neighbor's signature was in October of 2024. And then once we didn't get the other, that's when.
Thank you very much.
Thank you.
Public comment?
I think, is Dan Kearney?
Hi. Thank you all very much for having me. I appreciate it. My name's Dan Kearney. I live at 2012 West Vina Del Mar Boulevard. I'm the neighbor to the north, who apparently has refused to sign documents that he's never seen. Prior to pulling off the document online for the October of 24 signature that we're referring, letter of no obligation, that actually has someone else's signature on it and a notary where I was supposed to sign. I have never seen this document before pulling it off of this website, and it has someone else's signature on it. I have no idea who it is. We are disputing this because there clearly are other alternatives here. When we purchased our house in 2014, I believe, we had significant dock changes we needed to make to our dock to accommodate the boat slip and the jet ski lift that we wanted. It only had one slip for a boat, or I'm sorry, for a jet ski, no boat. We wanted to add a boat slip. So prior to purchasing a boat, we went through all of the regulations. We went through all of the permitting. It took us 8 months to accommodate that. We spent about $20,000 redoing our dock, and then we went and purchased a boat that would fit the dock so it wouldn't disrupt our neighbors. When our neighbors knew what we were doing with our dock, they were happy to sign off on the variance request that we had because it was so minimal and had no impact. This is one where they are correct. It has been tied up for 2 years, and I thank God that the multiple storms that we've had over the course of the last few years haven't gotten the boat loose and run into our dock or to the marina or anything else. So I appreciate that for how well you've tied it off. It's been great. I'm not opposed to having this secured properly. I want it to be done in a way that won't impact my property value and the use of my dock down the road. I eliminated significant square footage from my dock when I submitted the request to add on a boat slip. I had to completely reconfigure the end of the dock, and I lost an entire section of floating dock because I wanted to do it correctly. I did. I'm not sure that we're doing it that way this time. It's been 2 years, and apparently I was asked 2 years to go sign a document that I've never seen, that now I see off of your website that has someone else's signature on it that's been notarized. I'm concerned about that. We presented 3 different options of deck plans that may work. We submitted those to Kristen, and Brandon, thank you guys very much for all your emails. We really appreciate it. I'm not sure if they're all going to work. I'm not an expert. I'm not an attorney, and I'm not a boat contractor. I'm just trying to present some logical solutions here that would not impact my dock down the road should I choose to put a boat on the other side where the jet ski is right now, because having that slip on that side of the property would impact my ability to have a boat put there. Should I choose to sell my property down the line and somebody wants to put another boat slip there, it's going to impact their ability to do that, because they're going to have these two things protruding from the side of their dock that are impacting our ability to get a boat in and out. So again, I don't know if that's even feasible. I haven't taken out a tape measure, but there clearly are other alternatives. My own dock, as pictured in, it's not on there anymore, the side that is closest to our neighbors is a jet ski lift. The other side is the boat lift, and the boat lift doesn't come anywhere near our other property, our neighbor's property line. The jet ski doesn't come anywhere near, our south neighbor's property line. Prior to me purchasing the home, we looked up permitting and we saw that the people who owned the home before we owned it had 2 posts installed at the end of the dock into the waterway to put a sailboat there. My time is up. Apparently, the sailboat didn't last because, unfortunately, the gentleman who purchased the property and put the sailboat there passed away during the construction. So it seems as though there is a logical, appropriately permitted option of putting a boat at the end of it, as evidenced by 4 neighbors on the island of Vina that we live on. That's it. I'll stop right now. Thank you very much. I really appreciate it.
Thank you.
That's it.
Is that it? All right. We'll close open comment and open for board discussion. Yes.
I appreciate the comments, and I copy of it, and I put it in their door, and never heard anything back.
But just to confirm, the document with the signatures, it's signature for the neighbor to your south, and that's the signature that's on there. That is not the individual.
I wasn't representing that, it was his signature. I'm representing that I never received your signature.
Okay. Thank you for clarifying.
So there's nothing nefarious. Yeah, I'm a licensed CPA. Ethics are very important to me. One other thing I'd like to, can we see this? I'd like to dispute one aspect of this. So our property is the one to the south where you can't see it. It's number 10. And that distance between the sailboat and that jet ski lift is 35 feet. If you look up north from 9 to 10, his boat lift to the property a little further north is only 24 feet. So he's already living with a 24-foot difference, and this is where we've asked the contractor, and he said this is plenty of room. We wouldn't suggest something that wouldn't have enough room. So that's those are the couple of additional points I just wanted to make, and I thank you for your consideration.
Could we get testimony from Edge additionally, please? If you could just provide your expert opinion on the distance between the proposed sailboat and the neighboring property and the ability to navigate a boat safely.
Yeah, so that's, typically in most properties scenarios, and almost all of them, we can't design a structure or a slip or a lift where it's required to go over the property line and the riparian line out into the water to use the slip. So what we're proposing would in no way, shape, or form affect any neighbor's ability to use their slips, just like it's not going to affect our proposed or at our locations ability to use the new slip. No one would ever be within about 20 feet of the property line. Or I'm sorry, at our subject property, we're going to be about 10 off. The boat would never be closer than 12 feet from the line. And if I could get one more overhead shot. When we're talking about space, it might be hard to see, but that's the right setback line for the neighboring property, which it's hard to see, but that says 13 feet. And so what we're requesting, which would be on this side of the dock, that's where our 10.5-foot setback's going to be. So this is just an example how the neighboring property structure is within 13 feet of his northern property line. And yes, we are a little less because we're inheriting the location of the dock that's already there, but 10.5 to 13 is pretty close in similarity.
Thank you.
Thank you.
Reverting back to board discussion.
I'm having a hard time understanding why it would be difficult to navigate a jet ski into that dock.
It's not the jet ski, it's the idea of potentially other ship boats coming in. That's a really unusual part of water because of the traffic going to those two restaurants and the marina right across. So you've got limited room to get in, and the jet ski is not really the issue. The issue is like a sailboat or any other kind of motorboat.
Well, I think it is a question of a hardship. I mean, in the end, I appreciate needing to stabilize a sailboat. Yeah. Having said that, I mean, I think we know that there are solutions. They're just going to be more costly and would cause the existing dock to have to be reduced in its width in order to accommodate it on the current property line. I think it's really smart to, if you have two boats of those magnitudes, that you want to do that with the sailboat. I just see that there are solutions that don't impact neighboring property lines. And that's, I guess, where I look at this and think, I feel for this situation, but I think if this is the desire to have the sailboat moored here, that there would be a different structure for the current dock.
But I think then you're asking the property owner to take on what's maybe an unnecessary hardship from a construction perspective when we have testimony that as is, it's not going to negatively impact the neighbor's ability to use their property.
If it's unnecessary for, I mean, I could say it's unnecessary to have the second boat come in. I know that they took ownership in 2019 and they've had this new sailboat for the last 2 years. So what's unnecessary?
Well,
I mean,
if I may, and I had wrote down spring line because I could see that it wasn't moored with a spring line. You have to have that with a sailboat. And what's happened over the last couple of years, we've got Red, White, and Booze, and we have, what's
The wharf.
The wharf. They've added so many slips.
Yep.
And those boats are coming in and turning around and causing a wake. I go under that bridge all the time.
Me too.
And I understand, but
It's gotten significantly worse.
It has, and we don't even know what's going to happen with the
Paso Grove.
marina there because they've got they have a lot of work to do on that.
So like I said, I'm not making a case that the tide pools aren't critical. I absolutely believe that's the case. I think what I'm just looking at is the fact that the ownership of the property was 6+ years ago, and in the last 2 years, we've tried to moor a sailboat, and you recognize that it's not going to be a real stable place for the success of that, and now it's smart to add the additional tide poles. How can you do it within the current confines of the property? There are solutions, and I appreciate that. It's not ideal, but I do think that there are solutions within the confines of the current property.
I completely get where you're coming from. I also think that the majority of docks along our waterways have exceptions that are made, and usually we don't see them because neighbors are able to come together, and it's unfortunate when we have to be in this consideration because not everybody's going to be happy. That's just the nature of what we're faced with. I think their dock is minimal in size compared to what we see up and down the water. If they had a massive dock already, and then I might feel differently.
Different, yeah.
But I don't feel like they are asking for a large footprint for a dock and a sailboat relatively
They
to.
said they're not going to extend the dock at all.
Anyway, yeah.
I think it's reasonable to allow them to have these places to tie up with the spring. I think that makes sense.
Would you like to make a motion?
Oh, not yet.
I'll make a motion to approve case number 25141. based off the testimony heard today and the validated unnecessary and undue hardship variance.
Second.
Roll call, please. No.
Yes.
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 Yes. Do we have cases on the docket for next one?
At this time, we do have some under review, but I do not have any that have been deemed complete at this time. So there is a chance you may
Have a break.
have a break, maybe.
Any other items for discussion?
No, ma'am.
Meeting adjourned.
Thank you.